This is a continuation of the evidentiary hearing that began yesterday in the matter of the application of Artesian Water Company for an increase in water base rates filed April 4th, 2025. Yesterday, we concluded the presentation of the witnesses of the applicant and some other witnesses of staff. Today, we're going to continue with staff witnesses and then witnesses from on behalf of the Division of Public Advocate. So at that point, I'll call upon counsel to the staff, Ms. Workman, to introduce the next witness.
Thank you. Staff calls Ms. Maureen Reno to the stand and requests that she be sworn in.
I'm sorry, the name, please, again?
Maureen Reno.
Ms. Reno. Ms. Reno, would you please raise your right hand? You swear to tell the truth, the whole truth, and nothing but the truth, so help you God.
I do.
Thank you.
Can you hear me okay, Ms. Reno?
Yes, I can.
Okay, we can hear you well here.
Okay.
Do you have a copy of your direct testimony submitted as Exhibit 22 in this case in front of you?
Yes, I do.
Is that a true and correct copy of your testimony?
Yes.
Do you have any changes to your testimony?
No, I do not.
The staff has no further questions, and Ms. Reno is available for cross-examination.
Good morning, Your Honor. Good morning, Ms. Reno. Courtney Emerson. I'm counsel for the applicant. Ms. Reno, you are the Public Service Commission staff witness responsible for recommending a return on equity in this proceeding, correct?
Yes.
And your testimony recommends a return on equity that is lower than the company's proposed ROE, correct?
Yes.
Your ROE recommendation is part of staff's overall rate of return recommendation, correct?
Yes.
And you agree that under Hope and Bluefield, a utility must be given the opportunity to earn a return sufficient to attract capital on reasonable terms, correct?
Yes, that is correct. But also under Hope and Bluefield, in addition to an opportunity to earn a return, also that rate of return should not be so excessive such that rates are not just and reasonable.
And you agree that the allowed ROE must reflect investor required returns, not simply historical averages, correct?
That's correct.
On pages 59, lines 14 to 16 of your direct testimony, when critiquing Mr. D'Ascendis's predictive risk premium model, you state that it is a fallacy that expected returns should reflect total risk, correct?
Give me a minute to get there and review what you're asking me to comment on. You said page 59. What lines again?
14 to 16.
Okay, can you repeat the question?
When critiquing Mr. D'Ascendis's predictive risk premium model, you state that it's a fallacy that expected returns should reflect total risk. Is that correct?
Yes, those are my words.
Meaning that expected returns should only reflect systematic risk, essentially what you state, correct?
Yes, that's what I state in my testimony.
And systematic risk is measured by the beta coefficient, is that right?
Yes, and Artesian Resources has a lower beta coefficient than the proxy group at 0.7, and the proxy group average is 7.8. I mean, 0.78.
On page 29 of your testimony, if you could get there for me, please. at lines 19 to 20.
Okay, those I should have printed this out beforehand. Now I'm at the mercy of Microsoft Word. You said page 29?
Yes. Lines 19 to 20.
That's correct. I'm there.
When critiquing Mr. D'Ascendis' non-price regulated group, you state that investors considered more information than beta when comparing companies, correct?
Yes, that's what I state in my testimony. They
So
also
do,
look
go ahead.
they also look at the nature of the industries in which the companies are in, such in this case, water utilities. They also look at company financials, and those are all reflected in my ROE estimates.
So would you say that investors consider investment total risk or only the market risk?
Well, as I state later on, most investors have a diversified portfolio. So they tend to compare the utility risk relative to the market. And that would, assuming that they have a diversified portfolio, that would reduce some of the risk reflected.
ROE is not intended to be used to moderate rate outcomes or policy preferences unrelated to capital markets. Is that correct?
Can you repeat the question?
ROE is not intended to be used to moderate rate outcomes or policy preferences unrelated to capital markets. Is that correct?
Under the principles laid out in Hope and Bloomfield, that is one component of it. But we are to look at the commission is tasked with having more balanced approach, and that not only just looking at investors' perceptions of utility risk and required returns, but also considering fair and reasonable rates. So in my analysis, although it's primarily driven on what market expectations are set at, I am aware that the commission has a larger scope in setting a fair and reasonable return.
Okay, we can get into that. The cost of equity reflects the returns that investors expect, correct? In general, cost of
In
equity.
general, yes.
And that return is determined by market conditions. Is that correct?
It's determined by market conditions, but it's also determined on the nature of the industries in which a particular utility operates. And investors are aware that utilities are more defensive in nature, and that during times of uncertainty, where they can't diversify away total risk, investors are attracted to safe haven investments such as regulated utilities, in this case, water and wastewater utilities.
But a return would not be determined by a public policy preference. Is that correct?
That was not the goal of my analysis. My analysis is looking at what's happening in markets, what's happening in investor expectations. I am merely presenting these facts to the commission so that the commission can then decide. And in most jurisdictions in which I provide testimony, the commission usually has to play a balancing game between the interests of shareholders and the interests of ratepayers.
If an ROE is adjusted away from the market and total risk metrics, how does this policy affect the ability to attract capital?
Sorry, repeat the question.
If the ROE is adjusted away from the market and total risk metrics, how would that policy or practice affect the ability of the utility to attract new capital? Would it
That's
impair it?
Well, I'm not really sure how to answer that question because my analysis was driven by what the markets are reflecting. Also, how investors, what their expectations are of returns on water utilities such as Artesian water. So when I conducted my analysis, I didn't really have any policy goals in mind. I'm just merely reflecting what investors' expectations are.
So as you stated earlier, recommendation results in a lower ROE than the company proposes, correct?
Yes,
And that contributes to lower rates than the company's proposal. Is that correct?
but yes,
And your analysis is based on financial models and proxy groups, correct?
that's correct.
Those methods isolate investor expectations. Is that correct?
That's correct.
They do not include public sentiment. Is that right?
You were breaking up a little bit. I didn't hear to the whole question.
The financial models and proxy groups do not include public sentiment, correct? An analysis based on a proxy group that would isolate investor expectations would not include public sentiment analysis. Is that correct?
I'm not sure what you mean by public sector analysis, and because what we're talking about is investor.
Public
talking about-
sentiment, not sector. I'm sorry. Clarify.
What we're talking about here are investors' expectations, and that's what's reflected in my models.
Okay.
There
So
were no other influences in my assessment, and only company-specific information later on when I address the risk of Artesian water relative to the proxy group. I do state some facts in terms of various factors that might incorporate ways in which the commission has addressed risk for the company specifically. For example, access to rate mechanisms in between rate cases that would reduce the company's risk relative to the proxy group. I also look at financial metrics. Earlier we were talking a little bit about risk, and one key factor would be the beta coefficients, and that Artesian water, Artesian resources, the parent has a lower beta coefficient than the rest of the proxy group. So in that respect, investors see the water utility, in this case Artesian water, as less risky than the overall proxy group. So I would argue that even my ROE is probably an overestimate.
does your analysis include political views about utility profitability?
No,
Did you adjust your ROE for affordability concerns?
no, I did not.
Did you attempt to achieve a specific rate outcome?
Nope.
Are you aware of public commentary criticizing utility rates?
Only in a general sense. It's becoming more of an issue across the US in terms of affordability. And
And was your analysis impacted by that?
no, it wasn't.
So did your analysis incorporate in policy goals about keeping rates low?
No,
Did it include any views about whether utility profits are too high?
no,
Did you adjust your ROE for to achieve any specific rate outcome?
my analysis is based on methodologies I've been using for, I want to say, a quarter century, 25 years. And I've been consistent in the past few cases that I've been working. I've presented this analysis probably about close to 50 times, and my analysis has never been influenced by any sort of public sentiment, in that I would then adjust it. The only adjustments I have made were in relation to the company's risk relative to the proxy group. And so in most cases, what I typically do is choose the midpoint of my recommended range. And in this case, I approached it no different.
Have you had any communications with the governor's office or any legislators or their staff regarding ROE in this case?
No,
How about regarding this case in general?
no,
And have you received direction or guidance from anyone outside the record about what ROE to recommend?
no,
Were you given a target ROE?
no,
Does your recommendation reflect investor required returns only?
yes. And again, it comes forth in my analyses. You could open up my Excel spreadsheets and look at my approach. It's relatively clear. Unlike the company's witness, where he just throws a bunch of results that are biased upwards, and it really wasn't clear to me how he got his recommendation of the 10.6%. My analysis is relatively straightforward, and I could walk you through it if you'd like.
That's okay. So to clarify, if ROE were reduced due to external pressure, that would be inconsistent with Hope and Bluefield. Is that correct?
That's the only other guidance I see in Hope and Bluefield is that the allowed return not be excessive such that rates are just unreasonable. So, but my analysis was estimated using models that I've been practicing for quite some time, and based on investor sentiment as they're looking to invest in water utility assets compared to the overall market. And you'll see in my data, investors view water utilities as low risk and defensive. So my models portray a fairer ROE than what the company is presenting.
So a fair ROE, to be fair to the company, would require the company be provided the ability to attract new capital. Is that correct?
That's correct.
And an ROE is an opportunity to earn, not a guarantee to profit. Is that correct?
Yes, it's an opportunity.
Correct. Artesian was authorized a 9.50 RE in its last rate case just 2 years ago. Is that correct?
Yes,
And Tidewater Utilities, a similarly situated utility, was authorized a 9.50 ROE in a recent Delaware proceeding. Is that correct?
that's correct.
And your
But I wasn't
recommended, go ahead.
involved in that case, so I'm not really sure how the commission came to that number.
Okay.
I know that we're dealing with a different utility in different circumstances, and my analysis reflects market sentiment as we had discussed at great length earlier.
But your recommended ROE is materially lower than those 2 Delaware water utility awards. Is that correct?
Correct.
And you're not aware of any intervening collapse in capital markets since those awards, correct?
No, I'm not aware.
And rather than relying on Artesian's actual capital structure, you recommend an imputed capital structure. Is that correct?
That's correct.
You selected an equity ratio of approximately 50%, right?
Yes, I felt it was necessary to provide a hypothetical capital structure in this case because I had noticed that Artesian Resources and the utility have been gradually increasing the portion of equity. And so relative to the overall capital structure. And this is my way of making the commission aware that the company is choosing more equity than debt. Debt tends to be equity tends to be more expensive than debt. And it would have the result of resulting in an overall weighted average cost of capital or rate of return that would be excessive.
So you're recommending an equity ratio purely as a mechanism to put the commission on notice? Is that what you just said?
Correct, that's what I just said.
That equity ratio is not derived from Artesian's actual financing decisions. Is that correct?
Well, I know in the last rate case, the equity ratio was substantially, well, lower. It was around 51%. So what I'm noticing here is a gradual increase that the commission needs to be aware of.
Okay, so that's fine. Has the commission ever imputed a capital structure for Artesian in any of its rate proceedings over the last 20 or 30 years?
I'm not aware. I seem to recall the company witness saying since the 1980s, if you're going to go there.
It didn't. To clarify for the record, we didn't have a parent company in the 80s, 1980. Did you review the parent company's capitalization and the applicant's capitalization?
Yes, I did.
And are you aware that all long-term debt is issued at the subsidiary level?
Yes, I'm aware.
In reducing the equity ratio in the weighted cost of capital calculation, you effectively lower the expected equity return. Is that correct?
That's correct.
And you would agree then that your actual effective ROE recommended in this case is actually less than 9.05%, correct?
That's correct.
And you would agree that investors supply capital based on actual, not hypothetical capital structures. Is that correct?
Well, well, the different components of the capital structure are analyzed differently. If that's where you're going, the ROE reflects investor expectations of returns.
I'm only asking if it's analyzed on a hypothetical or an actual capital structure.
Well, investors and rating agencies look at actual financings, whether it be equity, debt.
So it would seem reasonable to use the actual capital structure rather than an imputed capital structure that was derived for the purpose of notifying the commission?
I wouldn't say reasonable. I'm just stating that's what rating agencies, investors look at. It is common practice for utility public service commissions to use a hypothetical capital structure if they believe that the actual capital structure is not reasonable. Here is in my analysis, I simply present that the capital structure, the equity ratio in particular, has been increasing gradually over time, and the commission needs to be aware of that as they're making a decision of balancing the interests of investors and ratepayers.
Your ROE analysis relies primarily on market models applied to proxy companies. Is that correct?
Correct. But as I said, in going with the midpoint of my range, I did consider specific risk factors of the regulated utility, Artesian, compared to the proxy group. And I found that Artesian Resources, Artesian Water Company has comparable risk compared to the proxy group.
Do you know Tidewater's capital structure in its last case?
I don't recall.
Did you include a flotation cost adjustment in your ROE recommendation?
No, I did not.
And flotation,
Because it's
go ahead.
about to state why. Because, it's my understanding that the commission is tasked with allowing recovery of costs specific to the utility. And the company's witness, Mr. DeSantis, estimated the flotation costs not based on the specific utility costs, but the costs associated with Artesian Resources, the parent. And for that reason, I rejected his flotation cost adjustment.
Well, flotation costs are real costs incurred when utilities raise equity capital. Is that correct?
It's correct, but they should be borne by investors and ratepayers.
So excluding flotation costs reduces the utility's required return below the allowed ROE. Is that correct?
That's correct. Again, those costs should be incurred by investors, not ratepayers.
Subject to you checking, would you agree that Tidewater's capital structure in its last case was 46.5 debt and 53.5 equity?
Subject to check.
Objection, Your Honor. She already said she doesn't know what Tidewater's capital structure is.
Understand, I think she said subject to check, so the answer is she's already testified that she really doesn't know.
I believe she testified that she did not recall, not that she did not know, but that's fine. Artesian faces significant ongoing capital requirements related to PFAS compliance. Is that correct?
That's correct, but it's a problem that most water utilities across the U.S. face. And so that's risk that's already reflected in the proxy group data points that I use to derive and estimate ROE in this case.
But those requirements increase financing needs and capital market exposure. Is that correct?
That's correct.
Staff recommends lower ROE while simultaneously acknowledging significant infrastructure and regulatory obligations. Is that correct?
That's correct, but these are costs that are recoverable. And in some cases, these costs are recoverable in between rate cases through various rate mechanisms.
The lower ROE compared to similarly situated water utilities, such as Tidewater, may result in a lower price for its shares or inability to attract required capital. Is that correct?
Well, investors look at all sorts of different factors. It would probably have some role, but these are the cost of doing business is already incorporated in investors' expectations and stock prices.
But you agree that given the significant infrastructure and regulatory obligations that those costs are increasing?
They're increasing, yeah, sure.
And your
But what I was
ROE recommendation is lower than recent Delaware precedent, correct?
That's correct. We had already discussed that.
And it relies on
again,
the imputed capital
Go ahead.
structure rather than the actual structure, correct?
That's correct.
And it excludes flotation cost and does not specifically adjust for PFAS-related risk. Is that correct?
That's correct.
And if it's
The PFAS risk is already incorporated in my analysis as I'm looking at other proxy group companies because it's an issue across the U.S. And so other water utilities deal with this and other environmental regulations. So the risk of doing so is already incorporated in my estimated ROE.
So all those utilities need to attract capital. If adopted, this risk understating the return necessary to attract capital for a capital-intensive water utility. Is that correct?
Repeat the question.
If your ROE was adopted, it would risk understating the return necessary to attract capital for a capital-intensive water utility. Is that correct?
My my ROE recommendation is based on what markets are telling me. So it wouldn't underestimate anything. It reflects what investors' expectations are in this current market.
Are you familiar with NARUC, the National Association of Regulatory Utility Commissioners?
Yes, I am.
And it's an association of state regulators, including commissions like this one. Is that correct?
Correct?
It develops guidance and identifies regulatory practices used by utility commissions across the country.
Yes.
And NARUC materials are commonly relied upon as statements of accepted regulatory principles. Is that correct?
That's correct.
And as a staff witness, your analysis is intended to be consistent with accepted regulatory standards. Is that correct?
That's correct.
And those standards are reflected not only in case law like Hope and Bluefield, but also in widely recognized regulatory guidance such as NARUC, correct?
That's correct.
And NARUC guidance addresses regulatory tools such as forward-looking mechanisms and recovery of capital investments. Is that correct?
That's correct.
And those types of tools are used to ensure that utilities can continue to invest in infrastructure and maintain service. Is that correct?
That's correct.
Can you please refer to cross-examination Exhibit 13, which should have been provided to you by your counsel? It would be DPA 5 rebuttal, sorry. It's DPA 5.2. Should be on the second page of that. Do you see that?
I see a highlighted text.
Okay, perfect. So for purposes of those in the room, this is the NARUC resolution supporting consideration of regulatory practices deemed as best practices dated July 27th, 2005. I would move this into the record as an exhibit
76.
number 76.
No objection from staff.
None from the DPA, Your Honor.
It's admitted as exhibit number 76.
If you go back a couple pages, you'll see the actual resolution supporting consideration of regulatory policies deemed as best practices. Do you see that?
Well, I thought we were referring to page 2, DPA 5.2 response A.
Yes, we did.
Okay.
And
But
then
then now you're saying go back a couple pages?
if you continue in that same document, at the end of the data request responses, there's the actual resolution. Do you see that? It's in that same file.
And what page is that on?
So if the data responses end on page number 7, and in that same file right behind it is a resolution.
Okay. I think I'm there.
Okay, great.
All the whereas
Yes,
clauses?
all the
Is that what you're talking
whereases.
about? Okay.
If you could go down to 1, 2, 3, 4, the 5th whereas clause. And if you could just read that whereas clause, please, out loud for the record.
Does it begin with to meet the challenges
Yes.
of the water and wastewater industry, which may face a combined capital investment requirement nearing $1 trillion over a 20-year period? The following policies and mechanisms are identified to help ensure sustainable practices and promoting needed capital investment and cost-effective rates. A, the use of prospectively relevant test years. B, the distribution cost improvement charge. C, construction work in progress. B, pass-through adjustments. E, my mouth is getting dry. Staff-assisted rate cases. F, consolidation. To achieve economies of scale. G, acquisition adjustment policies to promote consolidation and elimination of non-viable systems. H, a streamlined rate case process. I, mediation and settlement procedures. J, defined time frames for rate cases. K, integrated water resource management. L, a fair return on capital investment. And M, improved communications with ratepayers and stakeholders. And
then could you read the next one? It's a lot shorter, I promise.
whereas due to the massive capital investment required to meet current and future water quality and infrastructure requirements, adequately adjusting allowed equity returns to recognize industry risk in order to provide a fair return on invested capital was recognized as crucial. And
consistent with those accepted regulatory principles, your analysis is based on financial and regulatory standards, not public opinion or policy preferences, correct?
that's correct.
And also consistent therewith, returns on equity must be adequate to provide a fair return on invested capital. Is that correct?
That's correct.
And to be clear, the ROE that you're recommending is lower than Artesian's current ROE awarded just 2 years ago and lower than Tidewater's recently awarded ROE?
That's correct, but you need to keep in mind that my ROE is reflecting actual market information. And included in that, and this what I just read, my analysis also incorporates the risk of the utility relative to the proxy group. And I had just read a bunch of other mechanisms that are in play here that allow the company to recover their costs in between rate cases, thereby reducing their risk relative to the proxy group. So I feel that my recommended ROE is fair and reasonable.
Are you suggesting that the commission's award is arbitrary?
No,
Okay. I
definitely
don't
not.
have any further questions.
Do you have further questions, Ms. Emerson?
I do not. Thank you.
I have one question. Going back to the same thing that I asked previously, although you weren't here, Ms. Reno, you were talking about the hypothetical capital ratio that you recommended of 50-50 compared to the company's actual. Do you have a quick calculation as to what the difference would make with respect to revenue if we were to adopt one or the other? What's the difference in revenue between those two positions? Computer,
I believe, according to staff witness Ryan Paff, the effect would be $1.3 million.
in other words, what you're saying is, make sure I understand it, that if the commission were to adopt your hypothetical capital structure compared to the company's position, that it would reduce the company's revenue $1.3 million as requested. Am I correct in that?
Yes, it would also probably flow through and result in lower rates to customers.
Yes, understand. Thank you. Mr. Crumpler, do you have cross-examination for the witness?
And no cross-examination for this witness.
Just a couple quick redirects from staff. Ms. Reno, why is the do you remember talking about capital structure with Ms. Emerson?
Yes,
Why is the company's proposed capital structure not appropriate in your opinion?
it's not appropriate because what I'm noticing is an ever increasing portion of the capital structure going to equity. And since equity costs more than debt, I feel that the company's proposed equity ratio would result in an overall rate of return that would not be fair and reasonable.
Other than to purely put the commission on notice, why did you choose a 50-50 capital structure?
It balances the interests of investors and ratepayers. And as we discussed earlier, that is a primary directive of my understanding of the role of the Public Service Commission is to balance the interests of investors and ratepayers.
Thank you. That's all I have.
Your Honor, I have a few recross questions.
That are within the scope of what,
Yes.
thank you.
Over how many years did you measure this alleged change in the capital structure?
What was my observation based on the last rate case? The last rate case, I believe the approved capital structure was just shy of 51%. It might have been closer to 50% equity.
So to be clear, you mean the rate case that settled in 2024, just 2 years ago?
That's correct.
Okay. And where is that analysis in your testimony?
I believe I quote it probably in the section on capital structure. Keeping in mind too that also in that section, I also compare the company's proposed capital structure to industry's trends, showing that across the US, public service commissions and public utility commissions have been allowing lower equity ratios in the capital structure. I'm just trying to find that specific page.
And while
to
you're
put
looking
some
for it,
closure
if
on
you could tell me which work paper supports that.
So it's on pages 23 and 24. I also, when I can work paper, I might have referenced that in a footnote. Just bear with me a second. Oh wait, that's the wrong one. If you look at page 24, footnote 32, schedule MLR4 sample characteristics, I report the average and median equity ratios for the proxy group companies.
Which in
Another,
lines,
also on footnote 30, I reference the document by S&P Global Market Intelligence that shows water utility rate case data as recent as June 30th, 2025. I believe I might have updated that schedule and provided it as a work paper in response to discovery.
okay, I have no further questions.
I have one last question. Ms. Reno, somewhere in the testimonies, someone was asked, and this is my recollection, I can't go through all the documents right now, what the average total return was for water utilities in the country. I believe your return, if it's 50-50 capital structure and your rate of equity is 9.02, I recall that your rate of return for the company is about 6.47%. Is that correct?
Yes.
I thought I saw something that said the average in the country, and I'm not taking this to the bank, but I think I saw a testimony that someone said that the average rates of return for water utilities was 6.9%. Does that number mean anything to you? I'm not telling you that it's the Bible number, but I think I recall someone saying that in one of the testimonies.
I'm actually scanning my testimony now to find that specific quote. I believe I rely on that at some point.
Was it in your testimony? I'm not saying that it was. I just recall seeing it somewhere.
Right. Um, that sounds roughly in the neighborhood. Just for make things convenient for you, sir, I'm just trying to find the specific page where I provide that information. And again, my speed at which finding this document is more or less dependent on what Bill Gates will let me do in the moment. Just bear with me a minute. I might have mentioned it in the beginning of my testimony.
Once again, Ms. Reno, I'm not testifying or saying that it was in your testimony. I just don't recall where I read it.
Okay. But that sounds about right.
And so your recommended, with your recommended capital ratio and your rate of return of 9.02, your rate of return for the entire capital structure is 6.47%. That's correct?
Yes.
The company's position with respect to its ROE of 10.6 and its 53% equity, 53.8, I think, the overall rate of return was 7.51%. Is that correct?
That's correct.
And the just while we're on it, the DPA's with its position, the overall rate of return is 5.75%. I believe. It was not in
That
your
sounds about,
testimony.
yeah.
If you don't know
That,
this, I'm not
that
trying.
sounds about right. I think I skimmed Mr. Garrett's testimony, and I remember seeing that number, something close to it.
That's a request, not a statement. Thank you very much.
Your Honor,
No questions.
the information that you're looking for is on page 4 of Ms. Reno's testimony at lines 11 to 12, which says the average allowed ROR for water utilities in the U.S. in 2025 was 6.90%.
I'm sorry, where did you see that, Miss?
It's on page 4 of Ms. Reno's testimony at lines 11 to 12. The average allowed ROR for water utilities in the U.S. in 2025 was 6.90%.
Is that right, Miss Reno?
That's correct.
Thank you. I have no further questions.
Can we take a break before we call Mr. Paff? He's going to be a while.
The answer is yes. All right, after a brief recess, we'll start with the next witness from staff in this matter.
Staff calls Ryan Paff and asks that he be sworn in.
Mr. Papp, would you please raise your right hand? You swear the testimony you're about to give is your truth, the whole truth, and nothing but the truth, so help you God?
I do.
Let me just say that the reason that I was asked to swear in the witnesses today as opposed to yesterday was the court reporter doesn't have his license to what's it called? Notary license. I'm happy to do that.
Mr. Paff, do you have a copy of your direct testimony submitted in this case in front of you?
I do.
And is that a true and correct copy of your direct testimony?
It is.
Do you have any changes to your direct testimony?
I do. I have 5 changes. My first change is on page 9, line 13 to page 10, line 22. And that is the change is to withdraw the proposed capital employee benefits adjustment.
Can you please explain why you're withdrawing this adjustment from your testimony?
Sure. I received some additional clarification regarding Artesian's calculation methodology that was provided. And specifically, I had I had multiple data requests that didn't really get the answer that I needed. So on June 17th, I had a more prolonged discussion with the company, specifically Joseph Milligan. And we discussed what appeared to be an inconsistency between the payroll work papers and what was embedded in the revenue requirement. And we resolved it, and it's my understanding that the company is anticipating or at least pondering changing that schedule so such clarifications aren't necessary in the future.
Okay, thank you. Can you continue with your other changes you mentioned?
Yes, on page 12, line 12 to 13, the changes to delete the phrase as shown in the table below and add the following footnote: PSE charges line item of supplement and add the following footnote: PSE charges line item of supplemental schedule DBS 3H and docket number 230601 supplemental schedule DBS 3H.
Okay, thank you. What's your next change?
My next change is on page 15, line 11, and it's to replace the phrase "once the commission has issued its final order" with "once the commission has ruled on staff's proposed payroll adjustments." My next change is on page 17, lines 12 to 13. The change is to delete the phrase as shown in the table below and add the following footnote. Yes, and add the following footnote: PSE charges line item of supplemental schedule DBS 3H and docket number 230601 supplemental schedule DBS 3H. And my final correction is on page 28, line 1, and the related schedules, and that is to change the number 3,444,935 to 3,486,346. And the reason for that correction is that a formula error.
Does that conclude your changes to
It
your
does.
testimony? Other than those changes, if I asked you the same questions today, would your answers be the same?
They would.
Your Honor,
Just
Mr.
a second. What was the reason for the last change in terms of the number, Mr. Paff?
It was a cell reference error in Excel.
Understood. Thank you.
Your Honor, Mr. Paff's direct testimony has been admitted as Exhibit 19, and he is available for cross-examination.
Thank you. Ms. Emerson.
Good morning. I'd like to first start by clarifying one of the changes that you just made on the record.
Okay.
And it could just be me, but you should have a copy of your direct testimony in front of you.
I do, yes.
Excuse me, Ms. Emerson, when you're talking down and reading the thing, you need to keep that close to your mouth. Thank you very much.
Short people problems. And the second correction, page 12, lines 12 to 13. That doesn't line up with what's in my book.
Okay, I appreciate that, because when I was reading through those, it looked like there might be a duplicate. So I think that the second correction was incorrect.
Okay, so the page 12, line 12 to 13 is just, I can cross out this whole line on this chart. There's no
Yeah.
correction needed.
I think that
There.
that's the case. Yeah.
Okay,
My apologies for that, but thank you for clarifying that.
no problem. It is early. Okay. You did not analyze how quickly Artesian fills vacancies, correct?
Did I analyze how quickly Artesian fills vacancies? No, I didn't think that was necessary.
And you did not distinguish between temporary or long-term vacancies, is that correct?
That also is not necessary.
And you did not evaluate vacancy rates by department or job function, is that correct?
That's correct, yeah.
And you did not assess whether certain positions must remain filled for regulatory or operational reasons, is that correct?
That's correct.
Have you made any independent assessment of Artesian's employment needs relative to service provided to customers and in compliance with standard required business practices?
Can you repeat the question?
Have you made any independent assessment of Artesian's employment needs, so the number of employees we need and what type, relative to service provided to customers and in compliance with standard and required business practices?
I would say, in a sense, I have. I wouldn't have characterized it exactly that way, but I think in a sense that I have. And what I mean by that is that I looked at the previous vacancy rates from the previous periods, and it's my understanding that during all of those periods, Artesian was providing safe and reliable service to its customers. And so assuming that, assuming that they were able to do that with those vacancies, then I'm able to recognize that they can provide that service with those vacancies, if that helps.
Is it reasonable to also assume that Artesian may require additional employees to maintain quality service as it grows?
I think that is reasonable. I think that in this jurisdiction, it's my understanding that Artesian sets its rate. I apologize. Delaware sets its rates in this state as using a test period and then applying known and measurable changes to that test period.
Would you agree that our customer count has grown since the last rate case?
If you can point me to something in the record, or if you want to provide numbers, I can.
Do you know our customer count?
I don't know your customer count.
Do you?
Not offhand.
Do you know? So, would you also agree that our employee count has grown since our last rate case?
I believe that's the case. Yes.
And did the company provide the positions of the vacant positions for each of the days that were requested?
Did they provide the positions for each of the? Yes, I believe they did.
I'm just going to refer you to, you should have a cross-examination binder up there. And you'll go to tab CE1.
Okay.
I would just like to move this into record as evidence mark number 75.
77.
77. Do you see that this is a list of the vacant positions on each of the days that were requested?
Well, actually, I believe that this is a list of all positions.
Yes. And if you go to the bottom of each, so it's arranged in columns,
Yeah,
column being the date that.
I'm very familiar with this chart. Yes.
And then at the bottom, there is positions that are marked unfilled.
Correct.
Of each column.
I just wanted to clarify that it's not only
Yes.
vacant positions.
Okay.
Yes.
Thanks. So with those vacancies and the positions being provided, why did you not utilize the positions to determine an average level of wages that may be vacant, even recognizing that the information is only associated with one day of the year?
I don't think that would add anything to the analysis. In fact, I think it might detract from it in the sense that just because these particular vacancies exist on at one time, that doesn't mean that there wouldn't be other positions that would free up previously or free up subsequent to that.
So a vacancy on one specific day is not indicative of the vacancies over the entire year. You would agree to that?
I would say the vacancy of a single position is not the same because I would say the vacancies are fluid. And so as one position is filled, another position opens.
But you would agree that we wouldn't have the same number of vacancies on every day of the year. Is that correct?
I would say that, and I would also point out that I don't think that I would say that my analysis recognizes an average, essentially, of what the vacancies would be. Yeah.
Is it correct that since the adjustment is an annualized expense reduction of $1,623,967, it can be expressed in an estimate of total vacant positions in effect for the entire projected test period?
I believe I am following you, but can you state that question one more time?
Is it correct that since the adjustment is an annualized expense reduction, that it could be expressed in an estimate of total vacant positions in effect for the entire projected test period?
It would depend on the assumptions that are made, and I know that in Mr. Spate's discovery response, I believe, and maybe in his testimony yesterday, he referenced 15 positions.
Is it correct that if you divide Artesian's total test period payroll by total employee positions, using the pro forma payroll presented in your work papers of $26,277,784, the average wage per employee would be $104,276. $104,276.
I apologize. Those are a lot of numbers. And
I know. I like to say numbers slowly for court reporters just to get them. Is it correct that if you divide your total test period payroll by total employee positions using your 26 million number by the average wage per employee, that it would come out to $104,276?
I don't think that I've performed that calculation, so I would be happy to I'd be happy to do it, or
Okay.
we can.
So if you're
leave them subject to
fine,
check.
we can leave that subject to check and then use that as theoretical basis for this. But if you divided your adjustment by that average wage of $104,276, that the number of employees associated with your adjustment would be more than 15.
Again, I can go forward subject to check, but
That's fine.
I don't have a basis for agreeing or disagreeing.
Is it correct that reducing the company's current level of employees, which is 252, by that 15 would be 237, which is less than the 241 listed as of 1/1/22?
Again, I'm going to say subject to check because I don't have the calculations in
Okay,
front of me.
that's fine. Is it also correct that assuming no officer or highly compensated individual was listed as a vacant position, using the actual average wages for the named positions associated with the actual vacant positions used in your analysis rather than the total company average wage of $104,276 would result in a significant increase in total number of employees whose expense is effectively denied recovery accepting this adjustment? So in other words, if you had a highly compensated individual, would it then, if there was none of those in your average, would it then be more than 15 lower compensated individuals?
So you're asking, I think I get where you're going, but you're asking if we take the adjustment of 1.6 million as the numerator, and then the denominator is lower if that results in a higher number. Is that what you're saying?
Yes, a higher number of employees.
Higher number of employees.
Yes.
I would say mathematically, yes.
Your vacancy rate calculation uses only 3 data points. Is that correct?
It does use 3 data points, and I would just like to point out that those are historical data points, whereas the company's vacancy rate uses 1 data point that has never existed in my understanding.
Were the number of vacancies the same for every day, week, month of the test year and test period?
Were the vacancies the same for every day, week, and month of the test period?
Yes.
So essentially you're asking were they the same for every day of the test period?
Yes.
No, they definitely were not.
And you stated earlier that you calculated the average. Is that correct?
I did.
So your average was of 2 specific days rather than a true average of vacant positions throughout the test period?
My average that I used for this calculation was for had 3 data points.
Was it a weighted average or a simple average?
It was a simple average.
Your data points, well, I think you were starting to say this, were snapshots and they weren't averages over time, correct?
They were snapshots, correct?
And because you said that it was simple, you did not weight the data based on the duration of the vacancies. Is that correct?
Correct. And I believe from reviewing other testimonies and orders from different parts of the country, I think that's the standard way of doing it.
Referring to your revenue requirement model and work papers tab, vacancy rate average 3 years. You should have that in your testimony if you need to look at it, but you might be familiar. You indicate the source at the bottom of the table as response to discovery PSC 1.4B. Is that correct?
Can you refer me one more time? Was that to my testimony or was that to the binder?
It's your revenue requirement model and work papers in the tab vacancy rate average 3 year.
So it should be in this binder. Is that correct?
Yes.
And can you tell me the CE number?
Well, the CE is still the 1, but
Oh, I see.
your direct testimony is in the big one that, I'm sorry, so Exhibit 19.
Oh,
Of
so you're
volume
referring to my
three.
direct testimony.
Yes.
Oh, I'm
So
sorry.
in
apologies.
your revenue requirement model and work papers,
Yes.
you have a tab that's called vacancy rate average 3 years.
And I'm sorry, are you referring to my testimony or referring to my work papers?
Your model and work papers.
Okay, do I have that in either of these or?
It should be in volume 3, Exhibit 19. No. Okay. Well, disregard. But you relied on, in preparing your testimony, did you rely on their response in 1.4B, which is this chart that we've been looking at?
I did.
Okay. So you relied on a limited subset of data. Is that correct?
I mean, I think essentially all analysis is based on a limited subset of data in some respect, but I relied on 1.4B, yes.
Okay. And the company provided more years of information than you presented, correct?
They did.
And if you had included that information, your average would have been lower. Is that correct?
That is correct. And in fact, I thought about that as I was writing my testimony, and that's why I included, I probably don't need to get the line, but I included that average in my testimony to show what it would be if I included all 6 data points that were provided, just for transparency and in case the commission wanted to use something with more data points.
Did you provide anywhere in your testimony or your work papers the source of the average across the states that you cited earlier here today?
The average across the states.
You compared our average vacancy to vacancies at other utilities throughout the United States. And you said it was the standard methodology.
Well, I was never asked about that through discovery. And so if you want the entire response and the what occurred, I proposed this vacancy rate and I developed it. I actually developed it more or less independently just because I thought it was a logical adjustment. Based on Mr. Spate's testimony, he referred to the adjustment, and I believe he said it was extremely unique. And so I did additional research, to review whether or not it truly was extremely unique. And through a fairly quick internet search, I found maybe, I don't know, dozens or more of maybe dozens is pushing it, but I found several examples of where this vacancy rate occurred. And in fact, I've printed one out and I can speak to it if you'd like me to.
Well, so that is not in evidence, but none of those were provided in your work papers that accompanied your testimony. Is that correct?
Well, again, I didn't use it in my testimony. I began researching this after I saw Mr. Spate's rebuttal testimony that said it was extremely unique. I will say that we did not receive any discovery requests to provide examples of it. If we had, I would have provided it through discovery.
So you came up with a methodology on your own you used to calculate it, and then you went out and found similar ones after it was questioned. Is that?
Yes. Once I saw the assertion from the company that this was extremely unique, it was my understanding, not from I wasn't relying on anything specific, but from a general understanding and review, and having worked in this for, nearly 20 years, I've come across what I thought was vacancy rate adjustments that were similar. I didn't rely on any of those, which is why they weren't in my work papers. And then when I saw his comment, I did research and I identified others.
You applied a vacancy percentage to the total payroll, correct?
That is not correct. No, I applied it to the O&M portion.
Okay, but did you identify specific positions that were vacant?
Did I identify specific
Positions that were vacant
positions that were vacant?
in your application?
Well, no, because I was using a vacancy rate adjustment and applying that so that we could have a normalized view of the level of vacancies.
Did you analyze whether payroll costs were actually avoided?
Did I analyze whether payroll costs were actually avoided? Well, that's interesting because I think that the logical common sense interpretation of vacancy would be there will be costs avoided because the company's not paying those wages and benefits.
But if it's let's say, a one-day vacancy on that day, is it logical that the company was paying an employee the next day?
Can you say that one more time? I'm not sure.
If a vacancy existed for one day, is it logical then that the company was paying an employee on the next day?
If a vacancy was for one day and one day only.
Yes.
Okay, so just to make sure I understand, you have employee A that is employed until
They've announced their retirement.
March 15th, and
on
then
March 15th.
on March 17th, somebody else takes their place.
Correct.
Then, yes, I would agree with that. They are paying them. They do not pay them on March 16th. They pay them on March 17th.
How many of the vacancies relate to officer positions?
I'm not certain.
And how many of the positions relate to engineering, supervisory, or other highly compensated positions?
I'm not certain.
So did you determine the actual wage levels associated with each vacancy?
I did not.
Does applying an average vacancy level to total payroll reflect actual reductions in officer and highly compensated positions?
Well, I would say that it's used to modify the payroll amount to something that reflects a more normalized level. So it doesn't reflect any specific position or category of positions perfectly.
Your adjustment is approximately $1.6 million. Is that correct?
Yes.
And that amount can be expressed as a number of full-time equivalent employees. Is that correct?
If
Use the
you,
average.
I think we went through this previously, but if you assume a certain average level of compensation, then say yes.
Which we agreed subject to check was approximately 15 employees, correct?
I believe you said it was more than 15.
Yeah, it was 15 in a decimal.
Okay.
but
Okay.
That would reduce the workforce below the earlier levels reflected in the company data, correct?
Well, yes. I mean, it depends on what data you're talking about, but yes.
The company's actual vacancy rate at the end of the test period was lower than your average, correct?
It was lower. It was exceptionally low. Yes.
And you did not rely on that actual figure, correct?
The test period vacancy rate.
The one at the end of the test period.
Well, I did.
That was
I did in
acceptable.
part because it's part of my. It's part of the 3 data points that I use.
And would you agree that Artesian's service territory is growing?
I believe I've heard some testimony related to that. It wasn't a central part of, in this case, at least not in the testimony that I've read.
And you agreed that the company's employee base is trending upward over the relevant time period, correct?
That the employee base is trending upward.
The number of employees over
Yes.
the period of time.
And I would say that I reflect that because I apply the vacancy rate to the total employee amount, total or the total O&M portion of the payroll amount, not a subset of that.
Your vacancy adjustment is not based on actual staffing. It's not tied to specific positions, and it's not tied to actual avoided costs, correct?
It's well, if you could break that up, I think
Sure.
that'd be helpful.
So your vacancy adjustment's not based on actual staffing. Is that correct?
It's not based on actual staffing.
As in that it is the simple average of a handful of data points?
I'm hesitant to say it's not based on actual staffing because the data points themselves reflect actual staffing. I used an actual number, and as you might recall earlier, the company didn't use an actual number, so I'm trying to keep the distinction. But
You used
yeah.
1 day out of each year. Is that correct?
That's correct.
And then your vacancy adjustment was not tied to specific positions, correct?
That is correct.
And it was not tied to actual avoided cost. Is that correct? Like the 1 day example, you didn't analyze whether a vacancy was 1 day, 10 days, 30 days, and what those actual avoided costs may have been.
Yeah, I mean, there's a built-in assumption with the vacancy rate being that the employment is fluid, and so I did not look at a vacancy rate and say this was the vacancy rate for this period of time, or look at a specific employee and say this employee was not employed for this period of time. So there's a built-in assumption there that the data points that we used and that we received from the company are reflective of a normalized level of vacancies. And I would say that, if had the company provided additional data points that they felt were more reflective, we certainly would have taken those into account.
But to clarify, you testified earlier that you did not use all the data points that the company provided. Is that correct?
Well, I would say that I did include the average. I would say that I used 3 years because that's my understanding of how the number of periods that the commission prefers. But I'll say right now, my testimony would be if the commission believes that the 6 data points is more representative, then I would not be opposed to them using that figure.
Did you update your testimony based upon the DBS Mr. Spake's rebuttal exhibit number 1?
No,
Okay.
I did not.
And your testimony would need to be corrected to reflect any adjustment that Mr. Spake made in his rebuttal testimony, Exhibit 1.
I'm not certain about that. It may be.
Your adjustment relies, we're going to talk about the health insurance adjustments now.
Okay.
Your adjustment relies on BLS data, correct? Bureau of Labor Statistics.
My adjustment, yes.
Okay. And in your cross-examination binder at tab 6, there's a BLS table, and at tab 7, table 4, I would like to move these into evidence 78. So the item behind tab CE6 will be exhibit 78. That is table 3. And then the exhibit behind tab 7 will be 79. And that is table 4.
Is that it?
Yes.
Any objection? F?
No objection from staff, Your Honor. I don't, for 77, Miss Emerson, I know you referenced moving that in. I don't know if that was moved in. You just did 78 and 79, correct?
Yes.
So
77 was the one behind tab 1.
I'm just pointing out, I don't believe the hearing examiner
Okay. So
ruled on that.
yes.
No objection from staff to 77.
Mr. Crumbler,
No objection from the DPA, Your Honor.
moved into evidence as Exhibit 77.
Actually, if you wouldn't mind if I could clarify the previous point where you asked me if the Mr. Spate's revised payroll work papers would impact my calculation. I think that they would. I don't think it would be a material amount.
Your adjustment relies on the data in these two charts. Is that correct?
Well, it relies on this and the company's data, yes.
Okay. And that's the source of your percentages used in adjusting the company's benefit contributions?
That is, yes.
And the BLS study does not provide underlying inputs such as geography or demographics. Is that correct?
Well, it does relate to geography. If you look at, this was one of Mr. Spate's critiques of my analysis, is that I didn't use Northeast, but so it has different regions. And the other question was about the different the other question was about, what was the other question?
The demographics.
I don't see demographics on here.
And your adjustment was based on national data, correct?
That is correct.
Okay. Does the study provide the underlying input used to arrive at the percentages noted in the study, such as industry, state information, demographics, et cetera?
Does it provide the underlying, can you say that one more time? I apologize.
Well, are there regions used in the study other than the national averages?
Yes,
Okay.
I just said that.
And, but to clarify, those aren't the ones you used.
I did not, and if you'd like me to expand on that, I can, in the sense that I think that was a I think that was a fair critique on the part of Mr. Spade. I will say that I gave that thought about whether or not to change, and I decided to keep the national average, and because I don't think that the state of Delaware should necessarily be included in the Northeast, given that it's fairly uncharacteristic of other states in the Northeast that might be driving the average.
Did you independently verify the contribution levels in Delaware?
of the company?
No, just companies in Delaware in general, since you said that Delaware was not representative of, in your opinion, of the Northeast.
Yeah, so I didn't directly review the contribution percentages of every company in Delaware, but what I mean by that is that there's certain characteristics in Delaware that I think would lead to higher that would lead to the different percentages than would be assumed in other states. For example, the state of Delaware has fewer union positions as a percentage than other states of the Northeast, and unions generally have, because they negotiate for these types of things, they generally have greater benefits, lower premium costs.
Did you list those differentiating factors in your testimony?
No, again, I did this research subsequent to seeing Mr. Spates or Paul's testimony. I'll also say that we didn't receive any discovery requests about this.
Did you analyze differences in post-retirement benefits of the company and other Delaware employers?
Can you say that one more time?
Did you analyze differences in post-retirement benefits of the company and other Delaware employers?
No.
Do you know what the rate of contributions are for, as employers, the state of Delaware, Newcastle County, Kent County, Sussex County, governmental agencies in surrounding jurisdictions such as Maryland or Pennsylvania?
Do I know what the governmental agencies' contribution percentages are?
What the rate of benefit contributions are for those municipalities and government entities as employers? So, for example, if somebody works for Sussex County government, did you analyze what contribution those employees would pay?
I didn't. I don't even know how I would begin to do that, and I felt fairly comfortable given that this is a survey that's sponsored by the U.S. government, and I would also say that one of the reasons why I wouldn't even have thought to do that, and even if I had the thought, I wouldn't have done it, is because there's a distinction between private and state and local government that is included on this chart, for one, and then it is also included in, if you look at the BLS data that supports this and the assumptions, they specifically talk about how private and local and government should not be compared because the structures are just too different.
Would you agree that the company competes for employees from municipal and government agencies?
I'm sure that happens. I would say that they more often compete with other private industry entities.
You would agree that the public sector in Delaware provides a large amount of water and wastewater services in this state,
Yes.
and that they employ a large number of water and wastewater operators?
I guess it depends on how you define large number, but I would certainly agree that they would employ some.
Have you made an assessment as to whether any of those municipal or government agencies provide post-retirement benefits such as healthcare or defined benefits programs?
No, I did not. And I would say that generally when I perform these reviews, I'm not the one who's benchmarking the company's total compensation to other companies. That's generally the company that provides that information. and I reviewed and critiqued it. In this particular case, we didn't have much information. We didn't have any benchmarking data to support the employee contribution percentages. So if we'd have had that, if the company would have provided that information, then we certainly would have reviewed it and potentially relied on it.
Does the company provide post-retirement benefits for its employees?
I know it provides 401k. Yes.
Would whether the company provides post-retirement benefits be a factor in determining if the company's overall employment expenses were appropriate?
I can you say that one more time?
Would knowing whether the company provides post-retirement benefits, such as healthcare, defined benefit programs, et cetera, be a factor in your determination of whether the company's overall employment expenses were appropriate?
Yes, I think that an entire a look at everything is what I'd be looking for. Yes.
Would the company incur a significantly increased level of expense if it provided post-retirement benefits?
Well, I guess I would say that would depend on whether or not they continue to fund their 401k. I know that the 401k, I just looked at this in their 10K, and I can't give you the exact number, but I know that the costs were into the millions, and some employees, from my recollection, received upwards of or nearly $40,000 a year just from their 401ks. So if that were removed and replaced, then it could be a wash.
So if the company were to provide post-retirement medical benefits, would that increase or decrease the company's expense?
If we're holding everything else constant, then it would increase it, presumably.
Do all the companies who submitted information to this BLS study provide post-retirement benefits?
I believe that this is a nationwide study. Well, I mean, obviously it's a nationwide study and it's sponsored by the government. So I don't have a list of every company that that provided data for this survey.
Do the categories listed in the BLS study match the categories listed in the company's insurance carrier information provided to the parties in this application?
They do not match them exactly, but I made an assumption that I think it was a reasonable assumption in that if it were a single individual, and well, let me back up one point. There are multiple classifications that the company's health insurance carrier includes. This survey has two classifications: single and family. Single coverage and family coverage. And what I did in my analysis was the single employee, I could equate obviously with the single employee. And then for the family coverage, anything that was not a single employee from the employee in the company's data, I assumed as family coverage.
So you would equate a two-person coverage to a family coverage, which might include 6 kids?
Yeah, I actually looked this up because, again, this was a critique of that Mr. Spade had either in his testimony or in response to discovery. And from what I found through doing research is that a family coverage is considered two or more individuals. And I really couldn't think of a more reasonable assumption, given that to do anything else would be applying multiple people to something called single coverage.
We are referring in this discussion to the document that's at tab CE8. I would like to move that into evidence. It starts with the rebuttal set for 4.1. That whole document would be Exhibit 80.
Is there objection to that? Mr.
Objection from staff.
No
Ferguson,
objection from the DPA.
and it's moved into evidence as exhibit number 80.
Can you refer back to that tab CE6, please?
Yes.
That's Exhibit 78. If you look, it starts at the bottom of the first page. It says average wage within the following categories. And then on the next page, you'll see the characteristics are lowest 25%, lowest 10, second 25%, et cetera. Did you analyze our average wages in applying any of that information?
No.
Has this commission ever accepted an adjustment made using the BLS information in making such an adjustment?
To my knowledge, it's never been approved or proposed.
Has any intervening party in any rate case application submitted by Artesian ever suggested a similar adjustment based on BLS rates of contributions by employees?
Actually, Your Honor, I don't know how the witness would know about every application Artesian ever made.
I'm sorry, please repeat, Mr. Ferguson.
The objection is, counsel's asking about every application Artesian ever made.
Well, I think he can basically say he doesn't know.
Could you repeat the question, please?
Has any intervening party in any rate case application submitted by Artesian ever suggested a similar adjustment based on BLS rates of contributions by employees?
I'm not aware of any. I can't speak to every case.
That's fine. Thank you. We're going to discuss interaction allowance now. So if you could refer to your direct testimony, which is at Exhibit 19 of the Volume 3 binder that you have.
Yes.
And if you look at page 15, lines 10 through 15.
Yes.
The adjustment that you titled interaction allowance is your estimate of interactions among your other adjustments should all of your adjustments be accepted. Is that correct?
Can you say it one more time?
The adjustment that you titled interaction allowance in those lines is your estimate of interactions among your other adjustments should all of those adjustments be accepted. Is that correct?
It was the placeholder that I was using so that the commission would be able to evaluate these on a standalone basis.
Okay. And then that estimate may be materially different should your estimate have been miscalculated or your adjustments are not accepted, or if you have corrections because of formula errors, et cetera. Is that correct?
Yes, and that's why I would not recommend that this be carried forward into the final revenue requirement as I discuss elsewhere in my testimony.
Okay, so this just reflects the true-up that would occur once any adjustment is made to the final payroll and benefits, et cetera.
It's an estimate of that, yes.
Okay. And this adjustment itself is not a matter that we need to litigate. It's just a tool in summarizing your adjustments for ease of reference.
That's exactly, yeah,
Okay.
sorry to cut you off, but that's exactly right.
Perfect. Next, I'm going to move to rates case expenses. Did any party in the company's last rate case, which is 230601, object to or alter the company's amortization period for the compensation study or the depreciation study?
I do not recall.
Does this suggest that the company was not well, that's fine. If you believe that do you believe that the rates cases, hold on. Are you aware of any commission orders that disallow recovery of our rates case expenses?
Am I aware of any order that disallowed Artesian's rate case expenses?
Yes, in its rates cases, its previous rates cases.
Well, I believe in 14-132, there was an agreement amongst the parties of what the rate case expense would be, and that was significantly less than what the company proposed.
And is there a discussion in 14-132 of the disallowance of those expense recoveries?
I'm not sure that there is. From my recollection, it's phrased as a agreement amongst the parties to essentially not have to litigate that part of the case. That's my recollection.
Okay. Can you go to page 17 of your testimony, please?
I'm there.
At line 20, and then we're going to go through page 18, line 9. Did the company provide work papers and responses to data requests that include proposals submitted by consultants and discussions surrounding the use of those consultants?
For the company's consultants specifically, yes, not for all consultants used in this case.
Okay. And do you believe that the only sufficient evidence supporting the company's request for rate case expense recognition is through a bid process?
I do not, and I don't believe that I said that in my testimony.
Okay. We're going to talk about depreciation reserve adjustments now. What was the time period for the balances reflected in the depreciation study?
I believe that those were based on end of year 2022, perhaps. If you have it, you can ask me subject to check, but that's my or you can correct me, I should say. But that's my recollection.
And as the time passes between the study information and the completion of the application, is the information generally updated to reflect actual results, the balances, including known and measurable changes?
You're talking about during a rate case?
So if the depreciation study is approved, including the categories and the depreciation rates, is the information generally updated to apply that depreciation study with the actual balances, the actual known and measurable amounts?
I would say that the depreciation rates are applied to the updated balances, if that's what you're asking. I don't believe that was what was happening here, but I would agree with that statement.
Okay. Do you know if the company was required to update its balances for actual information recorded through the end of the test period in 230601, our last rates case?
I don't recall that, and I would also say that I don't believe that that would correlate if we're talking about the depreciation reserve. I don't believe that would correlate to the dates that they adjusted the depreciation reserve.
Do the minimum filing requirements require updates to those balances?
When you say those balances,
To actual information? Do the minimum filing requirements require the company to update its actuals?
I believe that the minimum filing requirement, if you're talking about a rate case,
Yes.
in the rate case. So I believe that the minimum filing requirements do allow for a partially projected test period.
Can you turn to cross exhibit 18 in your binder, please? This is copy of the minimum filing requirements of the Public Service Commission. I will move this in as Exhibit 80.
81.
I'm sorry, please.
I'm moving the minimum filing requirements, which is behind tab 18 of the cross-examination binder, into evidence as exhibit number 81.
Any objection, Mr. Ferguson?
No objection from staff.
Mr. Crumpler?
No objection from DPA.
So moved into evidence.
Can you please refer to 1.3.3, which is on the top of page 3?
Yes, I'm there.
Okay. Can you either review that and tell us what it said, or you can read it verbatim?
You were saying that updating projected test periods?
Yes.
Okay.
Could you just read that for the record, please?
Good. Updating projected test periods. If the proposed test period is other than the test year historic period, each quarter of projected utility data as filed shall be updated to actual utility data and provided to staff and all parties within 60 days after the close of the quarter, unless a later date for submitting this additional data is otherwise ordered by the hearing examiner.
Okay, thank you. So was the company required to submit updated information related to the depreciation study?
Well, there are a lot of factors here that I'm not. We would probably have to go to 230601 for me to be certain about that because it says if the proposed test period is other than the test year, each quarter of projected utility data as filed shall be updated to actual utility data. So I'm not certain about that. If in 230601 the test period was other than the test year, then I would say yes, they were required to update the data.
Okay. Did the depreciation study recommend a change in the underlying basis for accounting for depreciation expense for specific GL accounts, general ledger accounts?
They did. That's my understanding of what the depreciation reserve was related to.
Are you recommending or suggesting that valid investments made in plant are not recoverable in rates?
Can you point me to where in my testimony I say that?
I'm just asking you if that is your recommendation, that valid investments made in plant are not recoverable in rates.
No, that's not my recommendation.
Okay. Is the consequence of your adjustment denying recovery of the investment made in plant recorded to these accounts?
I would say no, and the reason I say that is because the depreciation reserve adjustment was a specific adjustment made by the depreciation witness in 230601. That depreciation witness provided a specific figure that was to be amortized over 5 years. I actually, after last night, I reviewed Mr. Spanos's testimony, and I don't see any indication in that testimony that describes how that figure would have to be revised and updated. He specifically says there's a 5-year amortization of this amount. And just to conclude my remarks, if I could, when asked in discovery to provide an explanation of this adjustment, that is the testimony that we were referred to.
So what is the mechanism for the company then to recover valid investments made between the time of the study and the end of the case?
Well, I can't say with certainty that this depreciation reserve adjustment provides for that because that was not included in the testimony we referred to.
We're going to talk next about the acquisition adjustment. Did the company provide support in both 230601 and in this application detailing the benefits derived from the acquisitions, which are the basis of the acquisition adjustment requested in this application?
They did.
Okay. Is your only observation or position in rejecting this acquisition adjustment that the MFRs do not permit such an adjustment?
No, I think that they, are you referring to a specific part of my testimony, or are you asking me generally?
So with your denial or recommended denial of the acquisition adjustment, is the only basis for that recommendation that the MFRs do not permit an acquisition adjustment?
It's not my understanding that the MFRs do not permit that. My issue is largely that I don't think that the company's acquisitions satisfy the requirements that are spelled out in specifically in the Tidewater case.
Did you review and provide your analysis of that or the alleged inadequacy of this acquisition in your testimony or in the work papers?
No, it was based on my professional judgment, and I will say that I think that it's helpful that the company is proposing this because there are I'm going from memory, but I believe in the Tidewater case it said if there are exceptional circumstances, then an acquisition adjustment may be approved and appropriate. My professional judgment was that these did not represent exceptional circumstances, but I don't think that that's clarified well. And so I'm hopeful that the commission gives us more guidance on that for the future.
Would you agree that the MFRs do permit companies to submit asset adjustments for consideration outside of the historical cost of the utility plant?
Yes.
And do you believe that the absence of any consideration of the specific components of that acquisition supports a denial of the request for the acquisition adjustment?
I'm sorry, could you repeat that?
So with the lack of, let's call it an asset by asset analysis of the acquisition adjustment, do you think that that analysis is satisfactory to deny an acquisition adjustment?
Do I believe that, are you referring to my analysis specifically?
Yeah, so your analysis specifically of Artesian's, not Tidewater's acquisition adjustment. Did you, let's break it down. Did you conduct, let's say, an asset by asset analysis of the plant and the assets in those acquisitions?
I reviewed Mr. Konstanski's testimony related to the acquisitions, and based on my professional judgment, I didn't believe that they were what I would consider exceptional. I also think that it would be I would also have difficulty if I were in the shoes of a commissioner granting something that was intended to be exceptional to 3 out of 3 cases.
Did you provide any of that analysis in your testimony?
Well, again, there was no specific written analysis. It was a review of Mr. Konstanski's testimony, or no specific written analysis. It was a review of Mr. Konstanski's testimony and review of the prior orders.
Did you review the basis upon which the Shady Park acquisition adjustment was approved by the hearing examiner and supported by the commission in PSC order number 6911?
I believe I did.
I've just referenced PSC order number 6911. That is behind exhibit tab number 10 in the cross-examination binder. I'd like to move that into evidence as 82.
She has moved that into evidence as Exhibit 82. Mr. Ferguson?
No objection from staff.
EPA?
No objection, Your Honor.
Without objection, it's moved into evidence as exhibit number 82.
Would it surprise you to know in that situation, the Shady Park, that the commission deemed it appropriate because Artesian had purchased a smaller utility that could or not or would not be able to meet water quality standards in the future?
Were you directing me to something in particular? I just want to make sure that I'm with you in terms of the documents.
You can look at the document, but I'm just asking if you're aware or if you were surprised to hear that the commission deemed this acquisition adjustment appropriate because Artesian had purchased a smaller water utility that wouldn't be able to meet water quality standards in the future.
It wouldn't. I would say that an acquisition is not an easy thing to accomplish. So my assumption would be that all acquisitions would have something compelling the different parties to enter into the acquisition.
Did you perform any analysis of assets acquired that benefited Artesian's customers before the acquisition?
I believe I did, but to be completely honest, I'm not certain if what I looked at was prior to or after my testimony.
Okay, so you couldn't point me today on the stand to something in your testimony showing that analysis?
That's correct.
Okay. And did the company provide information in both 0601, our last rates case, and in this application that provides similar support to that of the Shady Park acquisition that we just discussed?
I'm not sure what support was provided in the Shady Park acquisition.
So, as you recall, we just discussed that in the Shady Park acquisition, the commission deemed it appropriate because Artesian had acquired a smaller water utility that could and would not be able to provide to meet water quality standards in the future. Is that analogous to any of the acquisitions in this application?
I would have to look back at the different acquisitions. I can't think of them off the top of my head.
I have no further questions until Ms. Workman.
Mr. Ferguson. Excuse me, maybe Mr. Crumpler.
I have no questions, Your Honor.
Sorry, Mr. Ferguson.
Just a couple questions on redirect, Your Honor.
Please proceed.
Sir Paff, do you recall discussing with Ms. Emerson your vacancy rate adjustment?
I do.
Could you please expand on why the company's vacancies were not the same for every day of the test period and the relevance of that to your testimony and analysis, please?
Well, why they were not the same for every day of the test period, I would say is the reason why all companies, employees are not the same from day to day. It's fluid. People are leaving, being hired, et cetera, et cetera. Or I should say leaving and positions are being refilled, et cetera.
If a highly compensated position is not vacant on a certain date, does that mean one never will be?
No, it does not.
That's all I had, Your Honor.
Question I've asked other witnesses, Mr. Paff, do you have a quick calculation, or did you make a calculation, or maybe it's actually in your testimony, with respect to the major issues that you've just covered as to what the revenue, related revenue number would be with respect to the reduction from the filed position?
I do, and in fact, since I'm the revenue requirement witness, it's included in my testimony on page on page 5.
Could you just review it, please?
Um,
Is it long?
no, it's well, the staff recommends that the Artesian's requested increase of 9.9 million be reduced by 11.4 million, which which results in a revenue decrease of essentially 1.5 million. So all of the
Excuse me, I understand that, and we talked yesterday about how much of that was respect to the ROE. My question is, I'm trying to, you were talking substantially about the vacancy rates and some other things like that. Have you broken that out separately, or are you just talking about the overall number?
well,
Putting aside the ROE and putting aside, we also talked about the capital structure. I'm talking specifically about some of the things you were just talking about today.
yes, yeah. Thank you for the question, because this is a critical point. But you can look at my testimony, and the expense adjustments are all laid out. And if you,
Is it right there?
it is, yes. And for example, the vacancy rate adjustment on page 9, starting on line 10, discusses the decrease to the expense. And if you review my testimony and you see the expense adjustment, that can be equated with the revenue requirement.
I'll look at that again.
Yes.
I didn't keep all those numbers in my head.
Yes.
Thank you.
Yes. Thank you for the question.
The next, are you going to call another witness before lunch, staff, or are you, my understanding the lunch arrives at 12:30.
Yeah, we can call Catherine Hall if, I don't know if anyone has recross.
I'm sorry, I didn't ask. Any recross?
I do not. Thank you.
Thank you.
Is Mr. Paff excused?
Math is excused.
Thank you.
Take the rest of the day off.
Staff would like to call Catherine Hall as a witness and ask that she be sworn in when she's ready.
Sorry, I was just setting up my closed captions on the laptop. It looks like they're working, they're good. So I should be ready to start and proceed.
Are you ready, Ms. Hall?
Hmm?
Ready?
Sorry, what was that? Oh, yes.
Please raise your right hand.
Yeah. Oh, right. Sorry, this is my first time doing it.
Sorry, thank you. Mine too, almost. Do you swear to tell the truth, the whole truth, and nothing but the truth? So help you God.
Yes.
Thank you.
Can you please state your name and the name and address of your employer for the record?
Catherine Hall, Kathryn, and then Hall. My business address is 861 Silver Lake Boulevard, Suite 100, Dover, Delaware, 19904.
What is your role in this case?
I worked as an analyst. I was assigned to review certain expenses included in the company's application and the company's proposed non-rate related tariff changes. I filed testimony on February 20th, 2026.
Do you have a copy of your direct testimony submitted in this case in front of you?
Yes, I do.
Is that a true and correct copy of your direct testimony?
Yes, it is.
Do you have any corrections to your direct testimony?
Yes. There are 3 corrections I need to make in Schedule 5 of my Exhibit KH1. The first 2 are line 16 and line 21. The adjustment that staff made did not flow through to staff recommended amount. The staff total amount for line 16 should be $0 instead of $1,259. Similarly, the staff total amount for line 21 should be $0 instead of $2,000. The third correction would be to the total overall staff recommendations of Schedule 5. The total amount of line 37 should be reduced from 82,101 to 78,842.
Do you have any changes you would like to make to your direct testimony?
Yes, after further clarification from the company through responses to rebuttal data requests, as well as clarification provided during the evidentiary hearing, staff position regarding NASDAQ, OTC Markets Group, FMLA Lead Manager, and PA Institute of Certified Public Accountants has been changed and reflected on the schedules.
What are the effects of staff's change in position?
Starting with the corrected total of 78,842 for Schedule 5, staff's recommended position will increase from 78,842 to $145,841.25.
Thank you. I have no further questions. Ms. Hall is available for cross-examination.
Ms. Emerson.
Good afternoon. I want to clarify a couple of these changes before I get started. I received this chart from council regarding 4 categories of changes.
Ms. Emerson, I missed a question. So if this is about additional things staff accepted, then I can ask that now.
Please.
Ms. Hall?
Yes, I'm just trying to find where the exhibits would be. Testimony would be for me.
Yeah, I have one additional question for you that I missed. It was on the next page.
Oh, yes.
Do you have any other changes or modifications you would like to make to your direct testimony?
Yes, similar to the company's social and service club dues, any further explanation and clarification from the company through responses to rebuttal data requests. Staff accepts the company's proposed postage expense and tank painting expense.
Thank you. That is all I have.
Comptroller, any comments, any questions?
No questions, Your Honor.
Ms. Emerson, you finished with this witness?
I am not.
Oh, I'm sorry.
Yes. I would like to clarify there was a change discussed to line 37 from 82,101 to 78,142. That change was not on the chart I received from council, and just for my purposes and to speed this along, could you tell me what that change is for? It was line 37 of KH1 Schedule 5. So your testimony is at Exhibit 21?
Yes.
Okay. Okay.
It has been pulled up.
There was a correction that you just discussed with Ms. Workman to line 37. I just wanted to understand what that correction was for, the purpose of it. It's just the total, I believe.
Oh, the total? Yes, it was total. So originally, staff's total was 82,101 in my original exhibit. And we had been made changes, to increase that total in Schedule 5.
Okay, I think I understand now. That change reflects the addition of the $1,259 and the 2,000. Okay. I just want to briefly talk about Catholic Charities. Do you know when the company started its relationship with Catholic Charities?
I cannot answer the date of when it started. I know, as to my understanding, that it was not contested in docket 14132. As to prior to that, I have no frame of reference, and I will not be able to answer that.
Did you review the 2011 rates case?
No, I did not.
So subject to check, would you agree that the Catholic Charities expense was not removed in the 2011 rates case either?
Since I did not check, I will not be able to answer that.
Is your recommendation to deny the Catholic Charities expense based on the name of the account, the nature of the payments, or both?
Is the nature of both.
If a customer does not pay their water bill, do you know what happens?
I do not know the full extent of what happens. So I will leave that as I don't know. As far as I guess, as far as I do know is that customers may be fined or there may be disciplinary action to their charge to any water bills that they default on.
Okay. Do you know if a customer would be disconnected from water service, meaning their water's turned off if they don't pay their bill?
That is a possibility.
And if a customer does not pay their bill and the company exhausts all its ability to collect such a bill, do you know if the company has to write off the revenue to bad debt?
Can you repeat that, please?
If a customer does not pay their bill and the company, let's say, has shut off their water and has used all of its abilities to collect the bill but can't do it, does the company have to write off the revenue to bad debt?
I do not know.
Do you know if bad debt, which is what an unpaid water bill would become, is an expense that's recovered in rates from the customers?
I do not know.
Okay. So assuming that the rate effect of providing a resource through Catholic Charities to pay an invoice due to economic conditions a customer may be experiencing is identical to that of writing off an uncollectible bill from a customer, except that the customer would not be disconnected from service if the bill is paid through Catholic Charities. Does that result in a better experience for a customer experiencing financial hardship who can't pay their water bill?
Can you repeat that one more time?
Sure. So assuming that the rate effect of providing a resource through Catholic Charities, and by that I mean we've connected a customer with Catholic Charities then provides them economic assistance through our program to pay their water bill, meaning they don't get shut off. They keep their water on. They can take showers, cook, brush their teeth. The rate effect, meaning what the customer ends up paying, is the same. Does connecting that customer through Catholic Charities result in a better experience for the customer than the customer being shut off for non-payment of the water bill?
I would say yes.
Okay. And I just want to briefly talk about estimated bills and then we'll be done. I believe you have your testimony at Exhibit 21 in front of you. That's in that Volume 3 binder. Can you refer to pages 12 to 13? I'm sorry, it doesn't have page numbers, but you probably don't need to look at it.
Yeah, it just says, it doesn't have a specific page on here. I'm just gonna clarify. Is it the page where it starts with, estimated bill? And then the first question is staff proposing any additional changes to the company's
Yes.
tariff?
Yes, perfect. So you recommend that Artesian's tariff be modified by adding a section titled Estimated Bills. We are fine modifying our tariff, but we wanted to find out on the record, if we were to consent to the addition of that section, would you agree to the following language at the end of the section? The company reserves the right to access our meter to obtain an actual meter reading, and failure or refusal to provide access after reasonable notice shall violate the service terms. In such cases, the company may discontinue water service until adequate access is granted.
I'm going to object to that. She does not have authority to authorize that right now.
I think with that, I understand completely. And maybe her answer could be she doesn't have the authority. Witness, please.
Yeah, I do not have the authority to permit such a change.
Okay. I have no further questions.
We have no redirect.
Crumpler.
Nothing from the DPA, Your Honor.
Witness is excused. Job for your first time. Congratulations.
That concludes staff's witnesses.
It's a good time to take a break, Miss. Could I see Mr. Paff again? I just, this is off the record.
Your Honor,
We're
what
up-
time are we coming back?
What was that exhibit again? I'm trying to find it. I know I read it before. We're talking about the exhibit, the adjustments.
Oh,
What was it?
well, I was talking specifically about my testimony. I was talking specifically about my
I understand. Well,
testimony. What's
I'll look it up. The Artesian. The continuation of the hearing in connection with the Artesian water rate increase. I think that the staff has completed its list of witnesses, and now we're moving on to the DPA.
Correct, Your Honor. At this time, the Division of the Public Advocate calls David Garrett to the stand. Can you hear us okay, Mr. Garrett?
I can. Can you hear me?
Yes, sir.
Mr. Garrett, would you please raise your right hand? You solemnly swear that the testimony you're about to give is the truth, the whole truth, and nothing but the truth, so help you God.
I do.
Please proceed.
Good afternoon, Mr. Garrett. What's your full name, sir?
David Garrett.
And what's your occupation?
I'm the managing member of Resolve Utility Consulting.
Okay. And what is Resolve? What is your company point?
Provide expert consulting and expert witness services in public utility rate proceedings, and I primarily focus on capital recovery issues, including authorized rate of return and depreciation.
Okay. And Mr. Garrett, how long have you done this type of work?
I formed Resolve in 2016, so about 10 years.
Okay. And Mr. Garrett, you filed testimony in this matter on February 6th of 2026. Do you have any changes or modification to your filed testimony in this matter?
No.
Okay. At this time, I'd ask that this be moved into the evidence. It was previously marked as Exhibit 25, but because Mr. Garrett is testifying before Mr. Garrett, I don't know what. Okay, fine. So we'd ask this be moved into the record, or it's already been moved into the record as Exhibit 25. Those are all my questions for Mr. Garrett at this time. He's available for cross-examination.
Good afternoon, Mr. Garrett.
Good afternoon.
You are the DPA witness responsible for developing the return on equity recommendation in this case, correct?
Yes,
And no other DPA witness independently calculated an ROE, correct?
I don't believe so.
And Mr. Watkins relied entirely on your ROE recommendation in forming his own, is that correct?
I believe he did.
And you recommend a return on equity of 7.40% in this case, is that correct?
Yes,
And to be clear, an ROE is an opportunity to earn that rate, not a guaranteed profit, correct?
correct.
Artesian was authorized a 9.5 ROE in PSC Docket 230601 just 2 years ago. Is that correct?
That's my understanding. Yes.
And Tidewater Utilities, a similarly situated water utility here in Delaware, was also authorized a 9.50% ROE in April of 2025. Is that correct?
Yes, I believe that may have been the result of a settlement, but that's my understanding.
And your recommendation is more than 200 basis points below those recent Delaware Water Utility Awards. Is that correct?
Yes.
And are you aware of any collapse in capital markets during that time period?
Collapse in capital markets?
Yes.
No.
Okay. Rather than relying on Artesian's actual capital structure, you also recommend an imputed capital structure. Is that correct?
Yes, that's correct.
Just a clarification. You're saying that's what he relied upon instead or in addition?
That's his recommended capital structure in this case. In our 2023 case, the 230601, you accepted Artesian's actual capital structure. Is that correct?
I believe that's correct.
And in the 2023 case, the high end of your recommended ROE range was a 9.9%. Is that correct?
Subject to check. I don't have a reason to think that's not the case.
And the 9.9 would be 140 basis points higher than the ROE that you're recommending in this matter.
Now, what 9.9?
That would be 240 basis points higher.
I mean, I think that's correct about the math. And can you say again though what the 9.9
The
was referred to?
9.9, yep, certainly. The 9.9 was the high end of your recommended ROE range in the 23 case. And in this case, you're recommending a 740. So that's 250 basis points lower, correct?
Well, now I'm not sure that 9.9 was the high end of my recommended ROE range in the Artesian case. I'd have to double check that. It may have been the high end of my cost of equity modeling range, perhaps, but I don't know if that translated to, I think the commission should, I don't think I would have included 9.9% in a range of fair authorized ROEs, just to make that distinction. If
That's
you're
fine.
just asking about the difference in the math between 9.9 and 7.4, I believe you stated that correctly.
And your recommended ROE in this proceeding is the average of 3 separate models, correct?
Yes.
And those are the double leverage model, a CAPM analysis, and a sustainable growth DCF model, correct?
Yes.
And you weighted each of those models equally, correct?
Yes.
Your double leverage model assumes that the parent company issues debt and injects it as equity into the utility subsidiary. Is that correct?
I don't think it's dependent on the issuance of debt, but just that the parent company has debt on its balance sheet, and that debt is used in part to fund the equity of the subsidiary.
Just for the record, Artesian Resources Corporation, the parent, does not issue long-term debt, correct?
That's my understanding.
And all long-term debt is issued at the regulated subsidiary level. Is that correct?
I believe for this company, that's according to discovery responses, and I believe rebuttal testimony. I think that's my understanding based on that material. Yes.
And each of those issuances is required to be approved by this commission. Is that correct?
I'm not specifically aware of that, but I mean, that would not surprise me. I think that's pretty typical.
Okay. And since Artesian Resources does not issue debt, it could then not infuse debt into AWC, the utility subsidiary, and extract an equity return from it. Is that correct?
Well, I think it's still fair to characterize that, because the equity on the subsidiary's balance sheet isn't actually equity. I mean, capital's fungible, so we can't, the company doesn't keep, or I should say the companies between parent and subsidiaries don't keep separate buckets of what is debt and what is equity, but there's clearly debt in the total organization. So that equity portion on the subsidiary's balance sheet is not purely equity.
Clarifying that the company does actually keep those records, would you agree that the factual predicate required for double leverage would not exist here and does not exist here where the parent does not issue debt?
Can you say that one more time?
Since the parent entity, Artesian Resources, does not issue debt, the factual predicate for double leverage does not exist here. Is that correct?
I disagree with that. I don't think it changes my opinion. I mean, the parent is still reporting debt on its balance sheet. If that's a culmination of all of the subsidiaries' debt, then I think that's fine. But if you were to track the flow of that capital, combined with the fact that the equity on the subsidiary's balance sheet is not just like publicly traded issued equity either, I think it's still fair to say that a portion of that capital is comprised with debt.
Are you aware that each regulated utility entity, being Artesian Water Company, Artesian Wastewater Management, Inc., and Artesian Water Maryland, Inc., issues its own debt?
That's my understanding, yes.
To clarify, you included the double leverage ROE in your final ROE calculation, correct?
Yes.
You did not remove the double leverage model, even though the parent company does not issue debt. And okay.
That's correct.
And you did not apply different weights based on model reliability or factual applicability, correct?
That's correct.
So your final ROE reflects arithmetic, a simple averaging, rather than economic judgment, correct?
Well, I would agree that about the averaging part, but I don't agree with that it doesn't include judgment.
Okay. But to be clarified, it was a total divided by 3, essentially.
I applied equal weightings to each of the 3 models by using an arithmetic average of the models.
Okay. And you did not include flotation cost in your DCF or CAPM analyses, is that correct?
That's correct.
And flotation costs are real costs borne by investors, is that correct?
I mean, I suppose they're real costs. I think they're ultimately included in the share prices. So it's a real cost.
Okay. And excluding flotation cost lowers investors' realized returns below the allowed ROE, is that correct?
I don't think I agree with how you stated. Could you ask that one more time?
Does excluding flotation cost lower an investor's realized returns below the allowed ROE?
I don't think I don't think that's right.
Okay. Did you include any company-specific risk adjustment in your analysis?
Not a company specific risk adjustment in addition to the results of the DCF and CAPM. So not a quantified numerical adjustment for that.
And do you agree that under Hope and Bluefield, the allowed ROE must be sufficient to meet investor required returns?
Yes, I do agree with that because investor required returns, as I understand that, well, how it's generally understood in the industry, would be synonymous with the cost of equity. So the cost of equity from the company side is exactly equal to the required return on the investor side. Of course, those are matters of opinion. They can't be specifically calculated, but those two terms are really synonymous from different perspectives. And so I do believe that the key takeaway from Hope is that the authorized ROE should be based on, if not exactly equal to, the cost of equity.
Okay. Can you turn to your direct testimony, which is, well, it's our Exhibit 25. I believe you have an electronic version of it. And go to page 7, please.
Yes,
At
I'm
lines
there.
9 to 10. Oh. At lines 9 to 10, you say it is important to understand that the awarded return and the cost of capital are different but related concepts. Is that correct?
Yes.
So those two positions cannot both be correct, right?
Which two positions?
So that one, and then the one you just stated regarding that the ROE must be is equate to the cost of equity.
I'm sorry, I don't really follow the question. You-
So your position
So-
that you just took, I'm comparing that to what you said at lines 9 to 10.
Well, the lines 9 to 10, I think that's just a true statement that doesn't relate to anything that was what we discussed about Hope and Bluefield. Lines 9 and 10 should be an objectively correct statement. I mean, the awarded ROE, if a commissioner says an awarded ROE is 500%, well, let's use the word authorized. That's the authorized ROE. If a regulator says it's 2%, that's the authorized ROE. But I think we'd all agree under those extreme examples, that has nothing to do with the cost of equity or required return on investment for that utility or for any company. So,
So
go ahead.
under Hope and Bluefield, those cases require that the utility be given an opportunity to earn a return sufficient to attract capital. Is that correct?
Yes.
And that return must be comparable to returns on investments of similar risk. Is that correct?
Yes, that does reflect language from the case.
And that standard is based on financial market requirements, not on public policy preferences. Is that correct?
Yes, I would generally agree that when you're estimating the cost of equity, other factors, political factors or public policy factors, really should not influence that calculation because it's more an objective mathematical estimate.
Okay. Compared to the ROE that you're recommending of 7.40%, just for the record, the company is requesting 10.60%. Is that correct?
Yes.
So your recommendation is more than 300 basis points lower, correct?
Yes,
And that recommendation would result in a lower revenue requirement, correct?
correct.
The models that you use that we discussed previously, do they estimate investor required returns?
Yes,
Do they include public opinion?
no,
Do they incorporate policy goals of keeping rates low?
no. I mean, the models themselves certainly don't. And I think an objective application of the models would not bring into account these other things, or including authorized ROEs in other jurisdictions or in the past. Those aren't factors that directly impact market risk or the way that market risk affects individual firms.
So likewise, they would not incorporate views about utility profits being too high.
Technically, an application of these models should not incorporate those things. Now, whether a regulator incorporates those things, I mean, regulators, as I understand it, incorporate many things outside of the results of these models, of course, ultimately leading to authorized ROEs that are much higher than utility cost of equity, which has been my opinion since as long as I've been testifying on this issue. So clearly other factors affect the authorized ROE, but your line of questioning, I think, has been asking about investor required returns, which is synonymous with the cost of equity, which is estimated through these models. And those things should not be incorporating public opinion or policy or things like that.
Okay, thank you. Did you adjust your ROE for affordability considerations?
No,
Were you trying to obtain any specific rate outcome?
no,
Are you aware that there's been public discussion about utility rates being too high
You're talking generally or in the state of Delaware?
generally?
the topic of affordability does seem to be, I think it's fair to say that's a kind of a hot topic this year, and that subject has come up in multiple jurisdictions, whether it's from regulators, the public comments, and lawmakers as well.
Have you had communications with the Office of the Governor of the State of Delaware or any legislators or their offices regarding ROE in this case or regarding this case in general?
No,
Have you received direction or guidance from anyone outside the record about what ROE to recommend?
no,
Were you given a target ROE?
no.
Does your recommendation reflect investor required returns only?
Yes, in my opinion. Of course, some people can have different opinions on what the cost of equity or investor required returns are, but my answer to your question is yes.
And if ROE were hypothetically reduced due to external pressure, that would be inconsistent with Hope and Bluefield. Is that correct?
Well, it just takes a little bit of context to answer that. Technically, if an ROE is only being reduced for that reason, I guess you could say it doesn't comport with Hope and Bluefield standards, but because in the reality we live in, authorized ROEs are much higher than cost of equity and have been, I mean, as far back as I've reviewed this issue. So predating many years before I was even testifying, lowering the ROEs would bring it closer to cost of equity and would make it more in conformance to Hope and Bluefield. But you don't want to just do it for the sake of affordability, although affordability or lower rates will be a natural byproduct of this correct movement, in my opinion.
Okay, we understand your opinion. Does your ROE analysis include any adjustments for PFAS-related capital risk?
No,
Does it include adjustments for heightened infrastructure investment requirements?
No specific adjustment for that.
And yet those risks increase investor required returns, not decrease them, correct?
I don't think so.
So heightened risk does not increase investor required returns. Is that your position?
I think the factors you're asking about are firm-specific risks, and investors do not expect a return for firm-specific risks because they can be effectively eliminated through portfolio diversification, which is a cornerstone of modern portfolio and investment theory.
Your recommended ROE is well below recent Delaware precedent. Is that correct?
I don't know if, I mean, I think it's fair to say that as far as precedent goes, I mean, this issue is looked at on a case-by-case basis, but clearly my recommended ROE in this case is notably lower than past decisions in this jurisdiction.
And it relies in part on a model that, specifically the double leverage, that does not factually apply to Artesian, correct?
Well, we discussed that before. I disagree with, I know you're not testifying, but I disagree with the interpretation your questions were implying, that because Artesian doesn't issue its own debt, that this double leverage argument still wouldn't apply, whereas I think it still would apply. So the way you frame the question, I can't agree with it in that way.
But it does rely in part on the double leverage model. And it excludes flotation.
Sorry, go ahead.
It excludes flotation cost and company-specific risk, correct?
It does rely on the double leverage model. It does exclude flotation costs. It does not make an increase to the indicated cost of equity under the CAPM for firm-specific risk, which is a proper application of the CAPM as I understand it.
Okay. And if the commission adopted your recommended ROA, it would risk understating the return required to attract capital for a capital-intensive water utility. Is that correct?
In my opinion, it's not correct.
Okay. Are you familiar with the National Association of Regulatory Utility Commissioners, NARUC?
Yes,
And NARUC is an organization made up of state utility regulators, correct?
I believe so.
And it develops guidance and identifies regulatory practices used across jurisdictions, correct?
I think it does.
And materials published by NARUC are commonly relied upon by regulators and experts in this field, correct?
That's my general understanding, yes.
And that is because they reflect accepted regulatory principles and practices, correct?
I think that's generally true.
And informing opinions on utility rate making, experts may reasonably rely on those types of materials. Is that correct?
Yes,
NARUC guidance addresses topics such as ROE, capital attraction, and regulatory mechanisms. Is that correct?
I believe so.
Those topics are directly relevant to the issues you addressed in your testimony in this case, correct?
Yes,
And that is consistent with the Hope and Bluefield standards referenced earlier, correct?
the NARUC publications are consistent with
The regulatory principles, including, we can just skip to, you should have the NARUC resolution in your materials. For those in the room, it's CE 13. It's Exhibit 76. Yes, that's the tab. Do you have that?
I don't know if I do. I got some cross exhibits and
You may have one that's
resolution.
called Resolution 6, PSC R 5.2.
Yes, but when I pull that up, it's discovery responses for
So
some
if you
reason.
go to,
Oh.
yep,
Sorry.
if you go to the end of that file, you go
Oh,
past page 7.
I
There's
see it. Yeah.
all right.
Best practices.
Yes. So the principles of ROE, capital attraction, regulatory mechanism, they focus on ensuring that utilities have an opportunity to attract capital on reasonable terms. Is that correct?
I haven't read through this in detail, but if just answering your question generally at that. Actually, could you just repeat it one more time?
Sure. The topics addressed in NARUC guidance generally, including ROE, capital attraction, regulatory mechanisms, the principles that NARUC propounds on that focus on ensuring that utilities have an opportunity to attract capital on reasonable terms. Is that correct?
I don't know if that's their focus, but
Okay.
just based on reading this, I mean, but it wouldn't surprise me if that's just generally a factor that they would keep in mind.
So if you could perhaps read, a witness earlier read the 5th whereas clause, and I understand it's quite long and it's already on the record, so I won't ask you to do that. But if you read the 6th whereas clause, it starts with due to the massive capital investment. Could you just read that out loud for the record, please?
Yes, it says, whereas due to the massive capital investment required to meet current and future water quality and infrastructure requirements, adequately adjusting allowed equity returns to recognize industry risk in order to provide a fair return on invested capital was recognized as crucial.
So would you agree that NARUC guidance offers that returns on equity must be adequate to provide a fair return on invested capital?
Yes, I generally agree with that.
And to be clear, the ROE that you're recommending is substantially lower than Artesian's current ROE awarded just 2 years ago and lower than Tidewater's awarded ROA. Is that correct?
I agree with that.
Okay. And one thing, I just wanted to jump back to the double leverage discussion. Would you agree that double leverage is a financial strategy where a parent company uses debt to acquire equity in a subsidiary, relying on the subsidiary's dividends to cover the parent's interest payments?
Yes.
Okay. I'm going to walk you through this. If all debt issued is at the subsidiary level for each of our regulated entities that I went through earlier, water company, Maryland, and wastewater, and all of that debt is utilized in acquiring assets for that particular subsidiary, the water company, Maryland, or wastewater, and the only contribution to the parent is a portion of that subsidiary's net income, then how does the parent company issue debt and contribute that money to invest in the subsidiary?
Because the portion you mentioned that's net income, there's no separate baskets for the debt and equity. So that capital, the debt capital has flowed through effectively to that net income. It includes debt. And so it doesn't change my opinion that because the equity on the sub's balance sheet isn't actually equity, it has to include some debt because at the parent level, there's no completely separate baskets for debt and equity.
Okay. Hearing your opinion on that matter, I have no further questions for this witness.
Staff has no questions.
Just one or two questions. Mr. Garrett, If there are additional risks confronted by water utilities, are they reflected in the market cost of equity?
Well, I would say that the additional risks faced by water utilities that we should care about and account for are going to be reflected more directly through the beta term and the CAPM. Those are the type of risks that investors require a return for, the type of risks that impact cost of equity, and the only risk that you should calculate when estimating the cost of equity. Every company has lots of firm-specific risks, but investors can't expect an additional return for all of those risks, or required returns would be so much higher than they are now across the board, because every company has their own unique risks. Every company has a risk of imprudent management, for example. Enron, even though it's an old example now, is the example I use in my testimony. I mean, any company, your accounting department could be cooking the books and result in a financial collapse. It's a risk that every company faces, but you don't expect an extra return for that, because that type of return can be eliminated through diversification, which is one of the cornerstone concepts of what resulted ultimately in a Nobel Prize for the CAPM.
Those are all my questions. Thank you.
I do not, thank you.
Anything else for this witness?
No, Your Honor.
Patient. Garrett. Hughes. Second witness, Mr. Crumpler.
Yes, at this time, the Division of the Public Advocate calls Glenn Watkins to the stand.
Yes, Your Honor, can you hear me? Can you hear me?
Oh, we can hear you, Glenn.
Okay, thank you. Before we start, Your Honor, if I can beg your indulgence, I am dealing with an old man's Charlie horse right now that is killing me, so I might be asked permission to stand up because my leg is on fire right at the moment.
Want to introduce your witness, Mr. Crumpler?
Yeah, the Division of the Public Advocate calls Glenn Watkins to the stand. Needs to be sworn in. Glenn Watkins, sir.
Watkins, would you please put up your right hand? Mr. Watkins, do you swear to tell the truth, the whole truth, and nothing but the truth in your testimony? So help you God.
I do.
Mr. Watkins, can you hear me? Okay.
Yes, sir.
Okay. And what's your occupation, sir?
I'm an regulatory economist,
Okay. What's the name of your company, sir?
Technical Associates Incorporated.
And what's your position with Technical Associates?
I'm president and senior economist.
Okay. And how long have you been associated with this company in this line of work?
Almost 46 years.
Okay.
Since 1980.
Okay. And what is the purpose of your testimony before the Public Service Commission here today?
Yes, I was engaged by the public advocate to investigate virtually all aspects of the company's rate increase request, with the exception of cost of capital, capital structure, cost of equity, things of that nature, but specifically revenue requirement issues, cost of service, class cost of service, and rate design issues.
And Mr. Watkins, you filed testimony in this matter back in February 20th of 2026, correct?
Yes, sir.
And do you have any updates to your testimony since then?
I do, and I believe they were provided to the parties. And the update I have relates to purchase power expenses, in which initially I had rejected the company's proposed purchase power expense adjustments. But as indicated on page 17 of my direct testimony, I indicated if Artesian is able to provide an accurate and reasonable annualization adjustment relating to purchase power supply expenses during its rebuttal testimony, I will review and evaluate the company's calculations before the time of the hearing. As a result of the company's rebuttal testimony, they redid and revised their purchase power expenses in a much more robust and complete manner. And my review of that additional evidence put in the rebuttal case satisfied me that their rebuttal position on purchase power expenses are reasonable. Therefore, I've accepted that adjustment that they make in their rebuttal, and also accept the amount that they request for purchase power expenses. And that obviously impacts my recommended revenue requirement.
And when you say it obviously, how does it obviously impact it?
The revenue, my recommended revenue requirement is now a higher, well, a lower rate reduction. With this correction, with this update rather, my recommended revenue change is a reduction of $3,616,850. And I believe I provided, or council has provided to the parties, my revised revenue requirement schedules that pertain to this issue. And I've named them Schedule GAW blank revised.
Thank you, sir. And just a few questions. Sir, you were listening during the hearing yesterday, correct?
Yes, I was.
All right. During the hearing yesterday, Mr. Spake said you did not properly understand the rate-making treatment of AFUDC and CWIP. Do you agree with this assessment?
Your Honor,
no.
yesterday we entertained objections that this was not an opportunity to provide additional testimony.
I'm sorry, Ms. Summers, I don't understand your objection.
Yesterday, there were objections regarding questions made during the initial proffer of testimony that this was not an opportunity to provide additional testimony.
I agree with that.
I
would agree with her position on that.
Well,
Talked about it yesterday.
what Mr. Watkins is really trying to clarify the record. It's not providing a summary of his testimony, Your Honor.
Well, I thought you were providing a summary of his testimony, not cross-examining him.
Well, no, we're basically an update. There was an assumption based on the testimony that there was an agreement on the parties. Mr. Spate provided testimony saying that Mr. Watkins' his opinion on this issue is completely wrong, and then later talked about another issue that his position on tank painting was a fabrication, and we felt that it was necessary to address this at this hearing, Your Honor.
I agree with that. Please proceed.
Okay. So, Mr. Watkins, do you need me to repeat my question?
No, I think I have it, Counselor.
Okay.
I apologize. Just I'm going to read from a script that way. I won't be forever. No, I've been practicing public utility regulation for more than 45 years, and this commission is well aware of my credentials, as I have appeared before this commission for almost 2 decades and almost 40 cases. The company's counsel is more than welcome to voir dire me on this issue if they so desire. While I will discuss and present the actual facts relating to the company's request to include a portion of CWIP, construction work in progress, in rate base shortly, Mr. Spake's rebuttal testimony, as well as his testimony yesterday, is nothing more than an attempt to skirt the issue at hand and confuse the commission. The reality is that utilities are more often than not allowed to either include AFUDC or QUIP in rate base,
Your Honor,
not
this
both.
is beyond the scope of clarifying any dispute on the record yesterday.
Sorry, say that again, please. Would you please take, so I can see your lips move at the same time? Thank you.
This
It-
is beyond the scope of clarifying a dispute that was on the record yesterday.
Yeah, I'm inclined to agree with this. The general proposition here is that he's going to testify. You put his statement in the record. I don't think that this is a purpose to rebut something that was said yesterday.
Well-
I mean, you could have asked him yesterday about that.
Well, I did ask Mr. Spake about that, and he disagreed. There was the pre-filed testimony suggested that there was an agreement on the parties, and Mr. Spake said there wasn't. That's why I'm asking Mr. Watkins about these questions now.
Is this, I think it's a borderline. How long are you going to go on with this? Are you going to continue to ask him questions about Mr. Space's testimony?
There's only two questions, Your Honor.
Let's do it quickly then.
Thank you. Artesian's, in this case, the reality is Artesian's request is to include $4,229,791 of CWIP in rate base that only surfaced in Mr. Spack's 12+0 updated testimony. On page 3 of his final supplemental testimony, Mr. Spake's reasoning for requesting this inclusion of $4.2 million is because this project was not completed within the test period, but shortly thereafter, in October of 2025. Therefore, instead of characterizing this investment as plant and service shortly after the test year period, Mr. Spack is attempting to characterize this as construction work in progress. Indeed, and as I will show, the amount of Mr. Spack characterizes as CWIP is actually the total amount of the project placed in service after it was completed in October of 25. In this regard, the Delaware Administrative Code is clear in that it requires a matching of rate base, expense, and revenues for rate-making purposes. Clearly, if Mr. Spack had characterized this $4.2 million of investment as plant and service beyond the test period, it would violate the Administrative Code. As a result, Mr. Spack cleverly characterizes this project as construction work in progress to avoid violating the Administrative Code.
Your Honor, this is delving into argument on this issue.
I think at the very least, I'm going to let Mr. Spate reply to what he's saying for a second. And not right now, but if you could, Mr. Watkins, you're on the edge here of what's really appropriate at this point. And I'm going to let Mr. Spate in a second rebut this, but please go on and please keep it brief.
Thank you, sir.
If you've got another 3 pages, I'm going to disallow.
He doesn't, Your Honor.
I think then with that information, I will finish with the AFUDC CWIP issue, and perhaps we can talk about tank painting.
And sir, the tank painting issue, what exactly was that? Because your position was characterized as a fabrication yesterday.
Yes, it was. First, as shown in Mr. Spack's 12+0 Schedule 3B-7, the actual test period tank painting expense was $551,102. Mr. Spack does not attempt to normalize tank painting expense, but rather is requesting an expense allowance for future tank painting costs that will be incurred up to 3 years into the future. Remembering that the actual test period amount is $551,000, but as can be seen in my schedule GAW 9, page 1, I have not recommended the actual test period tank painting expenses, but rather recommend a much higher expense allowance of $864,870 which is based on a normalization of the company's tank painting activities. While Mr. Spack may not agree or like the analysis I performed, to characterize my analysis as a fabrication is frankly unprofessional and not true.
Please.
Those are all my questions at this time, Your Honor.
Okay, the staff, do you have questions?
Staff has no questions.
Ms. Emerson,
Your Honor, would you like Mr. Spake to reply now or?
would you like to cross-examine first, and then I'm going to let Mr. Spate talk. So let's do him first, and then I don't want to get this in a back and forth. Please summarize, and then we'll cut it off at that point.
I'll do it very quickly. At least I hope so. On the first matter, as it relates to the QUIP versus AFUDC, there was a notion of double counting that I was referring to. And I explained why in our situation, we are not double counting the effect of the interest recovery. That was what my argument was concerning. And that is why I went through that example on the stand yesterday. It was the notion of double counting the interest recovery. The company is simply trying to get the carrying cost of that asset, even though it wasn't completed at the end of the test period. That was the only way I could see putting it in. It wasn't a finished product. We've said that on the record. On the second point, my fabrication did not have anything to do with the calculation, the methodology, except to the extent that he imputed the expense of the future tanks painting that he divided by 17. He used the contract amount and then applied it to the other tanks in the thing, and then came up with a total average and a total amount divided by 17. That is what I said is a fabrication of the future expense. We used the contract that we had put into the case on the record of actual tank painting that will happen over the next 3 years, known and measurable.
I think we remember your arguments from yesterday.
That's it.
Ms. Emerson.
Mr. Watkins, a great deal of your testimony is about your preferences for Artesian's demand study. Is that correct?
I don't know if it's a great deal, but it is a section of my testimony.
What is your experience with performing formal demand studies?
Quite a bit, in the sense that I have not gone in the field and installed survey meters and things of that nature. However, over the last 45 years, I have reviewed dozens of demand studies based on load surveys to ensure that the sample sizes were correct, the time period was reasonable, the manner in which that they estimated loads were reasonable. And to be candid, Counselor, the vast majority of those were in the electric utility industry. As I indicated in my direct testimony, load studies have not been very prevalent in the water industry.
So to clarify, you've not performed any, but you have reviewed demand studies in electric cases.
Actually, that's not correct. Not to quibble with you. I was employed by Old Dominion Electric Cooperative in the mid '80s, and I did, not by myself, but with my engineering team, I did load studies for Northern Virginia Electric Co-op and it was either Southside Electric Co-op or A&N Cooperative.
So let's talk about perhaps a more recent demand study. What is the budget to complete one of these formal demand studies that you've reviewed?
I don't know.
Okay.
And what's interesting to me is Artesian doesn't even know what the cost is, or at least they haven't provided anything of what the cost might be, which is irrelevant, quite frankly, because the commission order is what it is and said you will do it.
And what were the project schedules in number of months from start to completion of a formal demand study?
It depends. I would agree with Dr. Blank's testimony yesterday. I would like to see at least 12 months of data. I believe there was a Suez water load study conducted, which is now part of Veolia in Pennsylvania. And if I'm not mistaken, that encompassed only 11 months, but there was a technical reason for that. But I would say 12 months would be sufficient.
Have you been personally responsible for implementing a formal demand study for a water utility?
No,
And have you managed a utility project team responsible for executing a formal demand study for a water
no,
utility?
that was the responsibility of the company as per the order in the 24 case.
And I believe you testified you've not been responsible for deploying meters in the field for a demand study.
That's correct.
And you've not overseen the installation of AMI or interval metering systems for purposes of a demand study. Is that correct?
Oh yeah, many times. That was not part of my engagement. But yeah, I've been in the field many a times looking at smart meters and AMI meters.
Okay. And has for water utilities?
I don't believe so. I don't believe I did a field audit or investigation of Veolia Suez. So I don't believe so. Not for water, no.
So your role for water utilities has been limited to reviewing or analyzing studies prepared by other people. Is that correct?
Yes, ma'am.
And your knowledge of formal demand studies is based largely on reports and studies prepared by others. Is that correct?
No, it's based on 45 years as an expert on this field.
45 years of performing formal demand studies for water utilities? Is that
Of
your testimony?
examining, reviewing, and analyzing demand studies conducted by utilities as required by the commissions.
Okay. And have you personally performed the field work required for a formal demand study for a water utility?
Objection, asked and answered. I think he's already answered that question.
This was about performing the field work required. I haven't gone on that topic yet.
That's okay. Can you repeat that question, please?
You've not personally performed the field work required for a formal demand study for a water utility. Is that correct?
That's correct.
And you've not personally managed the data collection process for hourly or daily consumption data for a water utility formal demand study. Is that correct?
Not for a water, but for more than one, I can recall 2 electric utilities.
Okay.
And in developing the sample size and the delineation across customer classes.
So your understanding of the practical field implementation of a formal demand study for a water utility is based on secondary review, not on a direct execution. Is that correct?
It's just based on my years of experience, what is and what is not required, particularly as it relates to putting a reasonable sample of hourly interval meter data for your sample size to conduct a study as required by the commission order.
Have you personally been responsible for developing a full project schedule for a formal demand study for a water utility?
Not for a water utility, but I did do one for NiSource in Indiana, as far as that goes.
Okay.
I was
And
part of a team, I should say, that developed that. But that was for natural gas.
okay, so not for water. And have you been
Yeah.
responsible for budgeting the full cost of a formal demand study for a water utility?
No, ma'am.
What is your experience with designing and the sample size and customer selection of a formal demand study for water utility?
Well, in my former life, when I was at ODEC, I was a forecasting economist, in which involves a lot of statistical analysis, including the development of required sample sizes. There's statistical mathematical determinations on how big a sample size should be. I don't remember them off the top of my head, but they're mathematical formulas that will tell you what the minimum or reasonable sample size would be with a given population and diversity.
Okay. But you haven't had personal experience in developing the sample size for a water utility formal demand study, is that correct?
Not for water, for electric and gas, yes.
Okay. And have you had personal experience establishing the screening criteria for selecting customers, such as eliminating new or seasonal customers for a formal demand study for a water utility?
Not for a water utility, for gas and electric, yes.
And for a water utility, for a formal demand study, do you need customer approval for them to be included in the sample?
That would depend on the tariff requirements, and quite frankly, I don't know what they are for Artesian, and it deals with access to customer premises for metering equipment.
Okay. And how many months does it take to establish and gather the sample population in a formal water utility demand study?
I guess it could vary, but so as I indicated, if we took our sampling of meter reads, interval meter reads, hourly meter reads, over a 12-month period, so you got a 12-month period starting there, then you have to collect and amalgamate the data. Fortunately, with computers, it's not all that hard anymore because it's all electronic, and then you have to evaluate it. So I would guess another 2 to 3 months, realistically.
But you've not personally been responsible for designing a sampling plan for a formal demand study for a water utility, correct?
I thought we went through that. Not for a water utility, for gas and electric. That is correct. There have been very, very few formal demand studies done in the water utility industry, and that's a problem with the industry. And that's exactly why we push for this formal demand study that was agreed to by the company and ordered by the commission.
And I understand your opinion on that. Have you been responsible for customer outreach to secure participation in a formal demand study for a water utility?
No, I don't believe any is required unless there's a provision in the tariff, because typically the utility has access to customer premises for all metering activities.
Are you aware that customer meters are sometimes located inside people's houses?
They may be.
Have you managed?
I don't know for sure. I don't
Okay.
know for sure, but they may be.
Have you managed issues such as customer refusal or non-participation in a formal demand study for a water utility?
No, but I have dealt quite extensively with customers' refusal to have smart meters put in their house because they think that, you know, the government will be watching them. That was an issue several years ago around the country. And
Right. And have you been responsible for ensuring that samples remained representative over time for a formal demand study for a water utility?
not for a water utility, but for gas and electric, yes.
And for a formal demand study for a water utility, what is your experience with selecting and installing the metering technology?
None.
Okay. Have you personally selected metering technology for a formal demand study for a water utility?
No, that's what the company's required to do.
Okay. And you're not responsible for specifying technical requirements for meter for any formal demand study for a water utility, correct?
Correct.
And you've not supervised meter installation crews for a water utility for a formal demand study, is that correct?
No, that's the responsibility of Artesian.
Okay. And what is your experience with selecting and installing software for a formal demand study for a water utility?
Nothing for a water utility, but you know, given the information technology that we have out there, different utilities, and quite frankly, I don't know what Artesian has, whether they would whether it would require additional software or not. But to the extent they do have some interval metering data for their industrial customers, I don't know. They may not need any. I just don't know if any would be required or not.
Okay. And you have not personally selected a software platform for collecting interval meter data for a formal demand study for a water utility?
No, again, that's the responsibility of Artesian.
Okay. And you've not overseen the IT implementation of such a formal demand study for a water utility?
Can you repeat the question?
Have you been responsible for testing, or have you, let's put it more generally, have you overseen the IT implementation, including cybersecurity, data integration, data transmission for a formal demand study for a water utility?
Not for a water utility. I was very much involved with Dominion Energy in Virginia in that very aspect several years ago.
And what is your experience with collecting and validating data from a formal demand study for a water utility?
I have never collected the data, but as far as validating the data, I did for Suez of Delaware I'm sorry, well, were they Suez back then? Yes, I believe they were. It's now Veolia, as well as Suez of Pennsylvania when they did their formal demand study, 8, 10, 11 years ago. Whatever. It's in my testimony, I believe.
And have you handled issues such as missing or erroneous meter reads for participants in the sample of a formal demand study for a water utility?
Absolutely, but not for a water utility, for gas and electric. Yes, that has been part of my reviews.
Okay. And have you determined when sufficient data has been collected for a formal demand study for a water utility?
Yes, in the Suez formal demand study that was conducted by a very good engineering firm, Gannett Fleming, we went over some of the erroneous data that they had to make adjustments for and assumptions as a result of that.
Okay.
Which I agreed with, by the way.
You performed that with Gannett Fleming?
Well, I reviewed it with and discussed it with Gannett Fleming. I'm fairly close with their principals.
How many water utilities have performed the formal demand study that you suggest that Artesian should perform?
I don't recall off the top of my head, Counselor, but I believe that was a data request that you propounded on me, so you should have that.
So, subject to check, would you agree that there have only been 2 water utility studies performed, and one of those was performed by the consultant for Veolia?
No, that's not true. Those are the 2 that I'm aware of. I know that there's been more in the entire industry, but those are the only 2 that I've been involved in.
Okay. So it's the only 2 you know of, but you know that there's more.
Correct.
Okay. So are you aware that approximately 1/3 of Veolia's customers currently have meters that are capable of providing the information necessary to perform a demand study?
That's irrelevant. That is irrelevant because, as Dr. Blank and I have said time and time again, this will require a sample of putting in interval meter data to conduct the study required and ordered by the commission.
It may be irrelevant, but I get to pick the question. So are you aware that 1/3 of them?
Well, I get to
Had the
respond. I
meters?
get to testify as
Asked and
to.
answered. I think he's answered the question. She
He
just
did not answer my.
Yes, he did. He said it's not irrelevant, and she just doesn't like his answer.
I asked if he was aware, which is a yes or no question, and he refuses to answer the question because he thinks it's irrelevant.
Would you repeat the question, please?
Are you aware that approximately 1/3 of Veolia's customers currently have meters that are capable of providing the information necessary to perform a demand study?
No, and that is irrelevant because,
Okay.
as we have said, if I can finish, because as Dr. Blanket and I have said repeatedly, this will require a sampling of putting in interval meter data that was envisioned at the very beginning of our discussions in the 2014 case. That was agreed to by the company and ordered by the commission.
Are you aware that approximately 1/3 of those Veolia customers that I just referenced had the required meters were chosen for the study?
Am I aware that 1/3 of the customers have the meters required to do this study? Did I understand that right?
1/3 of the customers that already had the meters were chosen for the study. Are you aware of that?
No, I
And
wasn't aware that they have chosen anybody for a formal study because they haven't done a formal study.
your testimony now is that Veolia did not perform a formal demand study?
I'm so sorry. I thought you were talking about Artesian. I apologize.
That's fine. Are you aware that Artesian, talk about Artesian now, does not have a customer with meters that are currently capable of providing the information necessary to perform a formal demand study?
That's my understanding.
How might potential changes in the company's metering technology factoring into timing of a formal demand study?
Is there a question there?
Yes. How might, so Recognizing that the company does not have any customers with the necessary meters means that to perform a formal demand study, there would necessarily be there would be changes to the company's metering technology.
No,
Nobody has those
no,
metering now.
no, I disagree. The way that, like, for example, Gannett Fleming did the study, Gannett Fleming provided those meters for the sample. So there's no requirement that necessarily that Artesian will have to go in and invest in meters. They may if they so choose, but that again is up to Artesian. So the point being, I don't know whether if Artesian ever does do the required study, they'll use a contractor to provide the metering equipment, or whether they'll purchase some of that themselves. I just don't know.
So regarding what you said earlier, that you would prefer at least 12 months of data to capture seasonal variation, correct?
Correct.
And because water usage varies significantly by season, is that correct?
Generally, yes, particularly for residential and small commercial customers.
So less than a full year of data would not reflect peak summer demand and lower winter usage, correct?
Well, it depends on the time period used. Like I think most of us would agree, we'd like to have a full year. However, if that wasn't possible, if we did, particularly the summer months where we have the highest usage, and then had a couple of shoulder months or winter months when it's not, the demand is not as great. It's not ideal, but if that's the best you can do, that's the best you can do. I hope that answers your question.
And before any data can be collected, the study has to be designed, the sample of customers has to be selected, the technology would have to be selected and installed, the software would have to be selected and installed, and all of that must take place before the data collection can even begin. Is that correct?
Yes, ma'am.
And after the data is collected, it must be validated, correct?
Correct.
And analyzed, correct?
Correct.
And then somebody like you would have to incorporate that into a cost of service study. Is that correct?
Well, the end results of the demand study would then be reflected in the cost of service study. I think we're saying the same thing.
So the total process includes setup time, data collection time, and analysis time, correct?
Yeah, I think that's fair.
Even under favorable conditions, a formal demand study would take well over a year to complete. Is that correct?
I think that's a fair assessment, yes.
And it could take multiple years depending on the amount of data you got, the selection time, the sample size, correct?
I would hope not. I don't think so. I don't think it would take that long, but certainly, over a year, maybe 2 years, but, multiple years, I think is stretching it.
Okay. And you're aware that the commission's order requiring a demand study was issued in June 2024, correct?
No, that's not what it says. It required a formal demand study in 2024.
Okay. And we filed this rates case in April 2025, correct?
That's right. That was your prerogative. And in your prerogative to file this rate case, when you hadn't completed the ordered formal demand study, I question why you filed at that point in time. But also, I observed that the company did not ask a waiver from the commission order requiring you to do it, even when you did file your rate case. That was all at the discretion of the company.
A formal demand study involves significant cost. Is that correct?
I think that it's what you say, significant. It's how one would define significant. I would say that they're not inconsequential. They are material costs, no doubt about it.
And those costs would include things like sampling design, meter procurement, installation, software, data collection, correct?
Yes, but maybe or maybe not need additional software. That I don't know, but all the others, you are correct.
And all of those costs would ultimately be borne by customers. Is that correct?
Perhaps.
And if the metering technology becomes obsolete, those costs may not provide long-term value, correct?
If what meters became obsolete?
The
The
meters
interval meter
required for
data?
this, yes.
Well, that's advanced technology. I can't imagine them becoming obsolete faster than your old-timey meters that you have in service right now.
Okay. The customers could be required to pay for both the initial system and a replacement system down the road, correct?
What kind of system, ma'am?
Replacement metering system.
The customers typically don't pay for the meters. The company does,
But those
which
customers
are
borne
of course
by
reflected
customers.
in
Hold
rates.
on.
Correct. Okay. And you did not quantify those potential duplicate costs in your testimony, correct?
Which duplicate costs are those, ma'am?
Paying for the initial system and a future replacement system of the metering technology?
No, my testimony simply addressed the fact that the company did not do what it was ordered to do.
And did you analyze the benefits of the study and whether they would outweigh the risks?
In the last case, if you look at my testimony, I have been critical of the company's cost of service study that goes back to 2000, at least 2004, I believe it is. It's in my testimony. And that is why the staff and the public advocate were so adamant in having a formal demand study done.
Did you independently calculate an ROE in this case?
No, ma'am.
And you relied entirely on the ROE analysis prepared by Mr. Garrett, is that correct?
Yes, ma'am.
And that analysis relied on an imputed capital structure rather than relying on Artesian's actual capital structure, is that correct?
That's my understanding.
And the purpose of an authorized ROE is to provide a regulated utility a reasonable opportunity to attract capital on reasonable terms, is that correct?
I don't know if you know this, but I also am a rate of return witness. The standard in Bluefield and Hope is to provide an opportunity to maintain and attract capital and ROE. That is sort of a minimum threshold. Now, various utility commissions have authorized ROEs higher than that, than the market cost of equity. And in fact, there was one case about 10 years ago in Washington, D.C. for Pepco, in which the commission authorized a lower ROE than the market cost of capital because the company did not adhere to the company's own directives to reduce their outages. So it goes both ways.
ROE, though, is not a guaranteed profit, correct?
Not unless you're in Virginia.
An ROE is intended to reflect investor required returns in capital markets, correct?
Yes, ma'am. Generally, the market cost of equity.
And you
believe it.
recommend that the commission adopt the lower end of Mr. Garrett's ROE range. Is that correct?
No, ma'am. I just use his recommended return on equity. That would have to be asked and answered by him.
Okay. And your recommendation is based on your view that Artesian failed to comply with aspects of a prior settlement. Is that correct?
Could you repeat the question, please? I'm sorry.
Your recommendation regarding ROE is based on your view that Artesian failed to comply with aspects of a prior settlement. Is that correct?
No, not at all. I simply used the recommendation of Mr. Garrett. Nothing more, nothing less.
want to confirm, you said, page 2 of your testimony, starting at lines 20, that with regard to the company's class cost of service study, the company did not comply with the commission order in its last case, PSC docket number 230601, wherein the company was directed to conduct a formal demand study as well as separate studies relating to meter and service cost ratios. Because of the company's failure to comply.
When you're reading, would you please slow down?
Yeah, and can you
What
tell me
page are
where the
you on
heck you
again?
are?
I'm on your direct testimony, page 2, line 20. And then we go
Oh.
into
Yes, ma'am, I see that.
3. So I was on page 3 at line 2. Because of the company's failure to comply with the commission's order, I recommend that no weight or credibility be given to the company's class cost of service study in this case. I further recommend that due to the company's noncompliance with the commission's order on these issues, the commission should authorize a return on equity, ROE, at the lower end of DPA witness Garrett's recommended ROE range. Is that your
See that.
testimony?
Yes, however, perhaps you have a misunderstanding. My recommended revenue requirement that I spoke to earlier of a reduction of $3,617,000 rounded, that's based on Mr. Garrett's recommended ROE. He has
Okay.
a lower range, whatever that is. So because of that, I'd recommend a further reduction than the 3.6 if the commission agrees with that. I did not make that calculation, however.
But you do say that I further recommend that due to the company's noncompliance with the commission's order on these issues, the commission should authorize an ROE at the lower end of DPA witness Garrett's recommended ROE range.
Yes, ma'am, that is correct.
Okay, thank you. And that recommendation, therefore, is not based on an independent capital market analysis. Is that correct?
No, it's quite frankly similar to the DC Commission where they punished Pepco for not complying with the prior orders and authorized a very low ROE for Pepco. Same analogy.
And you reviewed the company's response to DPA data request 1.1. Is that correct?
DPA 1.1.
Yes.
I don't know off the top of my head.
Okay, so you should have, for the people in the room, it's behind tab cross-examination number 5. It's been entered as Exhibit 73.
Okay, I have the package that you guys sent to me at 11:18 this morning. I've got them like CE3, CE5.
DE5.
Okay, thank you, dear. Thank you, ma'am. Yes, ma'am, I'm there.
Okay. In that response, the company explained that it does not have hourly consumption data and therefore cannot perform an AMI-based demand study. Is that correct?
Can you direct me to where that says that? I'm sure it does. I just don't see it.
It's on the second page in the response.
It's a second, third, fourth paragraph.
So you could start at the beginning. As an initial matter, the data required to perform a formal demand study as described in the M1 manual necessitates the use of AMI.
Yes, ma'am.
Okay.
Do you want me to read it into the record or what?
No, you don't need to review that, or you don't need to read it into the record.
Yeah, again, remember, we've talked about this ad nauseum. The concept is to do a sample, not every bloody meter in the service area.
Right, correct. And you would agree that the AWWA M1 manual itself provides a less sophisticated method using available system data when hourly data is not available. Is that correct?
I'm well aware of that. That's why I was very careful. And I personally wrote the terms of the settlement agreement. And that's why I was very careful in choosing the words that I did in the settlement agreement and that appeared in the order.
And the manual does not require a utility to generate data it does not have. Is that correct?
No, but the commission did.
And where does the commission order Artesian to generate data that it does not have?
It ordered the company to conduct a formal demand study that would require the determination of hourly and daily load variances by customer
And
class.
the AWWA manual specifically provides alternative procedures using existing system and billing data when detailed data is unavailable, correct?
That is correct. That's why we demanded and requested, and the commission ordered a formal demand study, not an alternative half-baked second best, if you will.
And Chapter 9 addresses demand-related cost allocation using class-level demand characteristics and peaking factors, not customer-specific interval data, correct?
I don't know off the top of my head.
Okay. It's in the manual. I could direct you to it, or we can agree that it does say that, but you seem to agree
Well,
with.
I don't know if this is important or not, but the manual that you provided today at 11/18 is the 8th edition that was not published until February of 2026. The AWWA manual that we worked off for both the settlement agreement and the commission order was the 7th edition, not the 8th. I've never even seen the 8th edition. So that's what you provided me today. So I don't know what it says.
Okay. Well, they both say the same thing, but they provide that we agree that it
No, we
allows
don't
for
agree.
cost allocation.
I don't know if we do agree. I mean, there's a 7th edition and an 8th edition. Clearly there's some sort of difference, isn't there? No?
There's differences between the 7th and 8th edition, but not material as it relates to this. And the witness already testifies that he agrees that there's alternative procedures using existing system and billing data when detailed data is unavailable is correct.
I guess that would be your testimony, not mine.
I don't think he's agreed to that. I think.
Do you agree that the M1 manual specifically provides alternative procedures using existing system and billing data when detailed data is unavailable?
It does, yes.
Okay. You do not claim that the alleged load study deficiencies increase Artesian's business risk in capital markets, do you?
I'm sorry, one more, I apologize. One more time, please.
You do not claim that the alleged load study deficiencies increase Artesian's business risk in capital markets, do you?
No.
And you do not claim that investors demand a lower return because of cost of service disputes, is that correct?
No, ma'am.
And you presented no empirical evidence linking those disputes to a lower cost of equity, is that correct?
No, other than my recommendation that the commission authorized the low end of Mr. Garrett's cost of capital, cost of equity, as a result of not complying with the commission order.
So your recommendation effectively lowers ROE to express dissatisfaction with other aspects of the company's previous rates case, is that correct?
That's a good way to put it.
And that approach uses ROE as a regulatory enforcement tool rather than a market-based measure, is that correct?
One more time.
The approach of lowering ROE to express dissatisfaction with other aspects of the company's previous case uses ROE as a regulatory enforcement tool rather than as a market-based measure. Is that correct?
I think that's reasonable. Yes.
And in fact, you would have the commission award a lower ROE to punish the company because the company disagreed with your interpretation of the AWWA manual. Is that correct?
No, not at all. It's simply because the company did not comply with the commission order, regardless of your interpretation. They did not comply with the commission order, plain and simple.
You can disagree with that, but you did not test the reasonableness of Mr. Garrett's ROE against Delaware precedent, correct?
No.
And you
There's
did
no
not
need to.
evaluate whether Mr. Garrett's ROE was consistent with recent water utility ROEs approved by this commission. Is that correct?
No, that was Mr. Garrett's role in this case.
And Mr. Garrett's ROE recommendation is already substantially below.
Yes, Senator Pettyjohn. No, Senator Pinckney. Yes, Senator Poor.
Mr. Wagner, can you mute
Senator
yourself?
Richardson. No, Senator Siegfried. Yes, Senator Sokola. Yes, Senator Sturgeon. Yes, Senator.
Mr. Garrett's ROE recommendation is already substantially below Delaware precedent, correct?
It's lower than the recent cases that have been settled at arm's length with give and take. It is quite a bit lower than that. That's correct.
And by recommending the lowest end of that range, your proposal further depresses the ROE. Is that correct?
It would be lower. That's correct. If the commission agrees with that recommendation.
And your ROE recommendation is not based on investor required returns, correct?
No, I don't make an ROE recommendation.
We just reviewed your testimony on page 3 that said, I further recommend that due to the company's noncompliance with the commission's order on these issues, the company should authorize a return on equity ROE at the lower end of DPA witness Garrett's recommended ROE range. Is that correct?
That's what it says. Yes, ma'am. Nothing more, nothing less.
And Mr. Garrett's recommendation that you're recommending the lower end of relies on an imputed capital structure rather than the company's actual structure. Is that correct?
I'm not sure if it's lower and does or does not reflect a different capital structure or not. I'm sure it's in his testimony. I just don't know, ma'am.
And it's based on policy judgments unrelated to capital markets. Is that correct?
That's correct.
And if adopted, it risks understating the return necessary to attract capital for a capital-intensive water utility. Is that correct?
That is correct. And that would certainly not violate the Supreme Court rules because it's similar to the Pepco case that was appealed and the DC Commission's punitive ROE allowance was upheld by the appellate court.
Your recommendation is tied, at least in part, to compliance or other considerations, correct?
Yes, ma'am.
That are not financial market inputs, correct?
That's correct.
And the cost of equity is determined by investor requirements, correct?
Generally, yes.
So reducing ROE for non-financial reasons moves away from cost of capital principles, correct?
No. You're conflating the two. Mr. Garrett's recommendation is based on the market cost of equity. My recommendation is to allow a lower rate of return based on the low end of the market cost of equity determined by Mr. Garrett, which are still market-based.
Are you aware of public statements about utility rates being too high?
Oh, yeah. It's the flavor of the day.
Have you had any communications with elected officials or their offices about desired outcomes in this case?
No, none whatsoever.
Were you directed or advised by anybody to recommend a rate or ROE decrease?
No.
And your recommendation should be based solely on record evidence. Is that correct?
Yes.
And external pressure would not be consistent with rate making standards. Is that correct?
I have no external pressure, and I have had a client in the past to provide external pressure. And to be quite honest with you, was in North Carolina, the Attorney General was running for governor, and I fired him.
Okay. Have you received direction or guidance from anyone outside the record about what ROE to recommend?
No, ma'am.
Were you given a target ROE?
I didn't do ROE, ma'am. That's Mr. Garrett's job, not mine.
I understand, but you did recommend an ROE at the lower end of a range. And I just want to ensure that you were not given a target ROE by anyone.
No, ma'am.
Does your recommendation reflect investor required returns only?
Whatever Mr. Garrett recommends is based on his analysis, not mine.
And if the ROE were reduced to external pressure, that would be inconsistent with Hope and Bluefield, correct?
I don't know. I'll let you interpret that. I don't believe so, because remember that Mr. Garrett's low end of his range is still based on the market cost of equity and still would comport with Bluefield and Hope as well, the Permian Basin.
I was just asking hypothetically if there was external pressure regarding lowering rates or setting a specific ROE and you adopted
I don't know. That would depend on the circumstances, so I can't answer that.
Okay. I'm going to turn to acquisition adjustments for a moment.
Okay.
Your analysis of the acquisition adjustment focuses on original cost or first recorded book cost, correct?
Yes, ma'am.
And you understand that those concepts are explicitly referenced in the Delaware rate-based statute, is that correct?
Yes.
And referring to your direct testimony at page 9, line 8.
Yes, ma'am.
Okay. So that is, you, yep. You asked whether Artesian provided any justification for its proposed acquisition adjustments based on prior decisions, correct?
Yes, ma'am.
And you refer to a response to a data request, is that correct?
Yes, I believe you're referring to PSC.
8.3.
Actually, I'm not sure which one it is. Actually, I'm not sure. But yes, I believe I do.
So it is 8.3 that we're discussing. For those in the room, it's behind tab CE19. It should be perhaps labeled that way in your files. And I would like to move this into evidence 83.
And that's behind Exhibit 19?
That's correct.
And which document is behind it?
It is, the exhibit is responses to 8th set of data requests. 19 of the cross-examination binder. And it will be moved in as Exhibit 83.
No objection from staff.
Gumpler?
No objection.
That's moved into the record as exhibit number 83.
Did the company provide any other testimony or exhibits that respond to your question regarding justification?
In rebuttal testimony, and I apologize, I'm going to mispronounce his name, Mr. Kaczynski or
Konstanski?
He provided quite a bit of his assertions, or the company's assertions regarding benefits that he perceived that customers may receive as a result of the acquisitions.
Did you review the testimony regarding the same subject in his direct testimony?
At some point in time, that was almost a year, more than a year ago. I don't recall.
Did you analyze and provide your opinion of any of the information provided in that direct or rebuttal testimony or in the data request response or referenced in Docket 230601?
I did. As part of my investigation, I evaluated the company's assertions on the benefits to Artesian's customers as a result.
Is that in your testimony?
No, it was not needed in my testimony. I set forth my reason for disallowing it.
Okay.
The perceived benefits are the assertions, just those assertions of the company. I wouldn't expect the company to say, oh, we purchased these well above book value and there are negative benefits to the customers. I mean, that's expected.
Okay. Did you analyze whether any of those acquisitions improved system reliability?
I did. In fact, if I can refer you to Mr. Konstanski's rebuttal testimony, which I believe there was some similar stuff earlier on. I'm not going to go through all of it, but even though his testimony is not paginated, he talks about the benefits of the Delaware City and the Fort DuPont acquisition. And as you go through that, you will see that the benefits accrue to the customers within those two acquired systems, not to Artesian's legacy customers. I don't deny that as a result of you paying a premium to buy those two utilities, that those customers within Fort DuPont and Delaware City may receive some benefits.
Okay. Did you?
But why should? But the rhetorical question is, why should Artesian's ratepayers pay for something that you saw as an opportunity to improve service for those acquired systems?
Did you analyze?
And then, I'm not finished with my answer, unfortunately. And then when we move to, in fact, I'll read from Mr. Kaczynski's rebuttal. Artesian's primary purpose in acquiring the Delaware City water system was to join it with the neighboring Fort DuPont water systems so that each system could address the other shortcomings. Furthermore, Mr. Kaczynski talks about the growth, the future growth. When we set utility rates, we don't speculate on future growth where you're going to get additional revenue and have additional costs. That's why we have a test period. And then finally, with respect to the town of Clayton, the benefactors of that acquisition were the citizens ratepayers of the town of Clayton because they received a premium for that. I see no extraordinary benefits to Artesian's ratepayers as a result of that. I'm not saying it was not a good idea to pay that price for it, but ratepayers should not pay for it. And furthermore, I do refer to a very similar case on page 8 and 9 of my testimony regarding Tidewater, in which a very similar situation happened and the commission gave a very good order denying acquisition adjustments.
Okay. Did you analyze whether any of those acquisitions avoided the need for the company to construct new facilities?
No, but again, well, yes and no, because in reading Mr. and I apologize, Konstanski's testimony, he's talking about really particularly for Delaware City or Fort DuPont future growth. Yeah, future growth. We don't regulate in Delaware based on future growth. We have this matching principle. So if there's future growth, that would be plant held for future use that's not used and useful. So to that extent, yes, I did.
Okay. So aside from future growth, did you analyze whether any of those acquisitions obviated the need to construct facilities for existing customers?
Not specifically, but what I rest in reaching my opinion, I rested largely on the commission's finding in order number 5592 involving Tidewater Utilities that what is provided in bottom of page 8 and page 9. And the key words are, the commission does not consider this case to present the exceptional circumstances under which the commission might consider doing so. I have seen nothing exceptional about the company's request for an acquisition premium.
So if these acquisitions obviate the need to construct additional facilities to serve existing customers, and therefore the company does not have to build those, would you agree that all ratepayers benefit by not spending that money?
Not necessarily, and there's been no analysis provided other than assertions and allegations of the company. I have seen nothing to that effect. I'm not saying there's not. However, they're not exceptional. And furthermore, I think it's important to understand the magnitude of the company's proposed acquisition adjustment. And if you'll bear with me for just a minute, I can quantify that for you. That is the acquisition. Bear with me just a minute, please. Acquisition adjustment. Here we go. Which is contained in my schedule GAW 4. So the company is requesting a rate base adjustment of, it's in my testimony. I got to subtract something. I apologize for that. There's a table in my testimony, page 7. Yes. So the company's proposed rate base adjustment associated with the acquisition premiums, $3,486,000. the revenue requirement associated with that is roughly 10% of that. So it's roughly $350,000. And then in addition to that, the company proposes an amortization expense of $82,000. So, the revenue requirement impact of this proposal is what, about about $420,000 to $430,000, somewhere in that ballpark.
You're not an engineer, correct?
No, ma'am. At one time, I was a certified energy engineer, but I let that lapse years ago.
And you did not perform an engineering or operational study of the acquired systems, did you?
No, ma'am.
And you did not review system performance metrics before and after the acquisitions, did you?
I did not.
And did you conduct a facility by facility analysis of the assets that were acquired?
Not in any great detail.
And you did not determine what it would cost the company to replicate those assets today, correct?
Replicate what assets?
The acquired assets, if we had to build them new today?
No, but I am aware that in Delaware, we generally use asymmetric pricing to lower cost to market.
Your testimony focuses on subsection A of the statutory definition of rate base, correct?
I don't know them off the top of my head. Maybe you can help me. I don't have them memorized.
The section that you're citing is on page 8 of your testimony.
Okay, thank you. Thank you. Oh, I see. 261023.
Yes,
That-
the original
yes.
cost. Okay. And you did not analyze the portion of the statute that allows the commission to recognize other property necessary to the effective operation of the utility, correct?
I did evaluate that, and I'm very much aware of that. And again, going back to page 8, starting on line 18 through page 9, referring to the Tidewater case. I am aware, as was the commission, that they may consider other factors. However, they do not consider that acquisition to have exceptional circumstances, and neither do I. So I am aware of that provision.
Does your testimony provide analysis on whether the acquisitions produce benefits to customers?
No.
Have you
But
provided the commission?
let me finish. But in reviewing the assertions of the companies, I can see no perceptible benefits or exceptional, extraordinary benefits to customers. If there were, I'd be happy to. But I have seen nothing, no evidence supporting, quantifying any perceptible benefits to its existing ratepayers as a result of paying a premium for these other utilities.
So having not testified to the benefits accrued to other customers, you've not identified a specific adjustment that reflects those benefits then, correct?
I just answered that.
Okay. So if an acquisition provides facilities that the company would otherwise have to build and uses to service customers, you did not include that value in your analysis, correct?
That's your testimony, not mine.
I'm asking about the scope of your testimony.
I think that's already been answered by him.
This is literally the first time I'm asking this question.
I disagree with the characterization, so I cannot answer it.
Did you include a specific adjustment for the value of assets that the company would have otherwise had to build and that it uses to serve customers?
The presumption is that it would have to add an exceptional and extraordinary amount of additional facilities. I have seen no such analysis of that.
Okay.
Quantifiable analysis of that. Nor did I in the 24 case when you requested this same adjustment.
We're going to talk about chemicals for a moment.
Okay.
The company is proposing approximately $2 million in chemical expense, correct?
Let me get there, please.
You go to page 18 of your testimony.
Thank you so much.
It's in lines 1 and 2.
Yes, ma'am.
And your criticism is that you were uncertain how that number was developed, correct?
Yes, as indicated, it is uncertain in that they backed into these expenses. However, let me refresh my memory. Yes, and I do note that I did observe that the estimated is the same amount that the company requested in the last rate case. But you are correct in the sense that it is uncertain how they backed into these numbers.
And you're not testifying that the price of water treatment chemicals has decreased, correct?
Neither increased or decreased. What my recommendation is since the company has not met its burden of proof to allow the actual test period amounts for chemicals expense.
Did you conduct any independent analysis of chemical market prices?
No, ma'am, that's not my job. The burden of proof is on you, not me.
Did you obtain quotes or bids for water treatment chemicals?
Same answer.
And you did not dispute that chemical suppliers are no longer providing fixed annual pricing and instead provide short-term or variable quotes. Is that correct?
I don't know.
And you did not analyze the company's actual chemical bids or pricing submissions in this case, correct?
No, I did not, nor did I need to.
And you did not evaluate changes in water production volumes that would affect chemical usage, correct?
Yeah, for the volumes, I used the actual test period amount that would reflect the usage throughout the test period, which of course the higher is the usage, the higher is the chemical amounts that you have to use.
Okay. And did you analyze any operational or treatment requirements that drive chemical consumption?
No, again, the burden of proof is not on me, but is on your client, ma'am.
So as you're saying that your concern is with the company, how the company calculated the number, not with whether the chemicals are actually required to operate the system?
That's a fair characterization. Therefore, that's why I have utilized the actual amounts, and as set forth in the commission's decision in a DPL case, they prefer to use actual versus forecasted or estimated when actual data is available.
And your concern is not with whether the company actually incurs cost to purchase those chemicals, correct?
No, I used the exact cost that you did incur during the test period. $1,902,477.
Have you identified a specific amount within the company's chemical expense that you contend is unreasonable or imprudent?
I think my testimony is clear. I can't figure out what you did. You simply backed into numbers that are hard keyed. You don't show any calculations.
And would you agree that an expense supported by actual supplier pricing and operational needs can still be known and measurable?
Perhaps, perhaps not. I don't know. I would have to wait and see what it looked like. And are they forecasted amounts well beyond the test period? And did
All right, I want to briefly talk about IT expenses.
Okay. Can you help me with, hold on, I think I can find it real quick.
This is general.
Okay.
It's throughout your testimony.
Oh, I thought you were referring to page 24 specifically.
Oh, yeah,
I-
he could certainly go to page 24. if
I'm
you
sorry,
want.
go ahead. Thank you.
Would you agree that a contractual obligation is considered evidence of a known and measurable expense?
Well, yeah, but there's a lot of things that are known and measurable. The question then becomes for rate making, when does that contractual obligation become effective? Is it within the test period? Is it 2 years from now? Or what is it?
And you
And
state, Go
Are they based on, again, contracts that will be in place during the test period, or in which we can annualize those costs, like I have done and Mr. Spact has done on other occasions, annualizing expenses during the test period, as opposed to going out 2 or 3 years in the future, say, well, this is known and measurable, so you got to allow it. No, that's in violation of the administrative code, where you have the matching principle that is required for rate-based expenses and revenue.
do the minimum filing requirements permit utilities to file projected test period information?
They do.
And do the minimum filing requirements permit the inclusion of annualized and normalized information as known and measurable adjustments to actual expense?
They do. And again, like I have done that with my salary and wage adjustments. However, what they do not allow is a mismatch between future period costs, either whether it be rate base or expenses, and revenues. And as you have indicated, the company's customer base and revenues are growing over time. So if you're going to use a forecasted test period or test year, you need to be consistent.
Okay. Did the commission eliminate any of these adjustments in an order that purports to rewrite the minimum filing requirements?
I have no idea what you're talking about.
Did the Delaware Public Service Commission issue an order rewriting the minimum filing requirements?
As I understand it, and again, I'm not a lawyer, but as I understand it, they were approved and are in the administrative code as a matter of law.
Okay.
I hope that answers your question. I'm trying to.
Yes, that's good. I need to introduce one more exhibit. I don't have any questions for you on this, Mr. Watkins, so it's up to you whether you refer to it, but at CE2, it is data request to Artesian rebuttal set 2, PSC R 2.1.
Sorry, what tab is it?
CE2, cross-examination 2. Kate, what number am I on? 84. I would like to move this into evidence as Exhibit 84. It is behind tab CE2.
Would you describe it one more time, please?
It is responses to PSC rebuttal set 2.
You have any objection?
No objection.
No objections, moved into the evidence as Exhibit 84.
I have no further questions.
Thank you, Counsel.
You're welcome.
I missed that one. Was that good news?
I said I had no further questions. Mr.
I
Crumpler.
should have been paying more careful attention. Do you have any redirect?
One question or two. Mr. Watkins, you talked about a while ago what the company was ordered to do by the commission. Again, what was the company ordered to do previously by the commission?
I can give you a specific quote if you'll bear with me just a
Sure.
minute. And in fact, I quoted it in my testimony. AWC, Artesian, shall perform a formal demand study as described in Appendix A of the AWWA Principles of Water Utility Rates, Fees, and Charges Manual of Water Supply Practices, M1, that we refer to as the M1 manual. And then it also went on to require a study of the equivalent meter and service cost ratios, blah, blah, blah. And by the way, I should note for the record that in my direct testimony, I did state that the company did not conduct a meter service cost ratio study. But in the rebuttal testimony, Mr. Lyons did conduct that, and I'm satisfied with the meter cost study. The demand study, still is out there. But just for the record, I think Mr. Lyons did a good job in conducting an updated and improved meter and service cost ratio study.
And did the company do this formal demand study?
No, not at all.
Not at all. Did it do part of it? Did 75%, 20%?
Not in any way, shape, or form. In fact, in Mr. Lyons' cost of service study, and I'm not blaming Mr. Lyons, but in Mr. Lyons' cost of service study, I show throughout my testimony where some of the ratios that he uses are simply from the manual, and they say this is for these ratios are assumed for purposes of this example only. As an example, on page 52, lines 10 through 15, there's a clear indication of it. Again, that is not part of a formal demand study. It's just taking numbers that are hypothetical in a manual that is used for people to adhere to at least what AWWA thinks may be a second best approach. But again, that as indicated in the manual, even with that being said, the ratios that many of the ratios, not all, many of the ratios that Mr. Lyons used are explicitly for example purposes only, and they must be evaluated on a case-by-case basis, which he did not do. He just pulled the numbers straight out of the AWWA manual for this alternative approach to a formal demand study.
Those are all my questions.
Does the staff have additional?
Staff has no questions.
Are there additional witnesses?
Your Honor, I had a recross question, please.
I'm sorry, please, I missed that.
I have a recross question, please.
Yeah.
Oh, I'm sorry, recross. Yes, ma'am. Go ahead, please.
Mr. Watkins, can you open the exhibit CE 17 that you have?
CE 17.
Correct.
Is CE 17 that M1 manual that you provided?
Correct.
Yeah, that's 386 pages. There's no way in heck I printed out 400 pages since 11:15 this morning.
They didn't print it out for us either, so.
But it's also not the relevant M1 manual. Again, this wasn't published until February of 2026. The relevant M1 manual is the 7th edition. I have no idea what this new one says. I bet it's probably similar, but I don't know.
On page 95 of the PDF, and to be clear, it was not provided to counsel in the room per direction of the hearing examiner. But
Please speak up.
I said, to be clear, it was not provided in paper format to counsel in the room per direction of Your Honor, who requested voluminous exhibits only be provided in paper to the court reporter. But on page 95 of 397 of the PDF version, it says, in addition, provided billing periods are sufficiently short to reflect seasonal differences.
Courtney, what page are you on again?
95 of 397. it's page 70 on the top left, if that's what you're looking at.
Okay.
Says on page 95, in addition, provided billing periods are sufficiently short to reflect seasonal differences, customer billing information also provides a sound basis for determining class peaking factors. Mr. Watkins, do you agree that billing periods are sufficiently short at monthly billing to reflect seasonal differences?
Yeah, I don't know what that has to do with recross. That has nothing to do with my counsel asked me a few minutes ago.
Your counsel was asking you about this specific study and the adequacy of it.
All right.
And then on page 350 of the PDF, which is page 325 at the bottom. And this is AWWA Manual M1.
8th edition, I assume, what you're referring to? Okay.
Yes. And this is the Are we all ready?
Yeah.
Okay.
Ms. Emerson, is this within the scope of the redirect?
Yes. Council was asking about the adequacy of the study. This formal studies can be used to determine peaking factors by customer class. And this appendix outlines two methods, the coincident and non-coincident methods that utilize readily available billing and system data to provide adequate estimates of customer class peaking factors. Is that correct?
I don't disagree with what you're saying. I can't see it, but
Okay.
I'm fairly familiar with the M1 manual, so I'm not going to disagree with you. I've seen
Okay.
words to that effect. Yes.
Okay, thank you. I have no further questions.
You have, who's up?
Just a clarification, so this is the 8th edition, correct? What is there Mr. Watkins was testifying that previously you guys were using the 7th edition, but I haven't really received a clarification what, if any, there are differences there are between the 7th and 8th editions.
Those are both readily available. If you'd like to review, there's formatting changes.
Just formatting, but
The agreement does not say which version of the manual to use, so I would presume that a company would use the one in place. But regardless, Mr. Watkins has already testified that there are alternative methods in the AWWA manual. I have no further questions.
I just had a clarification. That's fine.
If any further,
Nothing from staff.
are there any further witnesses?
No other ones from DPA. No other witnesses, Your Honor.
Yes, okay. Right, then I think the answer is, let me, before we go off the record, let's talk a little bit. We had some previous discussions before the hearing started. Would it be appropriate to put the issues with respect to briefing schedules and so forth on the record now?
That's fine, Your Honor.
Is that,
We agreed to a brief by August 24th, 2026, an answering brief by October 12th, 2026, and a reply brief if necessary by November 16th, 2026. And Ms. Workman
I
is,
think that's what we've agreed to, and that's acceptable. One other issue is that I had a brief offline discussion with a court reporter who believes that they're under orders to under contract to produce a record to the transcript by Friday. I don't think that's necessary from what I've heard here. So if I have the authority, I would like to try to extend that. Would anybody, or maybe 10 days or a week, would anybody object to that? With no objection, let's extend that for 10 days. Let's, staff has no objection to that?
Timon is saying that they have 2 weeks. The court reporter has 2 weeks from, Timon is saying that the court reporter has 2 weeks from today to get the transcripts to us.
Okay, well, I was told it was supposed to be done by Friday, and I was quite taken aback by that. 2 weeks is fine. Okay.
Your Honor, given the change in timeline, would the parties be agreeable to pushing each of those dates 2 weeks? We had originally scheduled those based on a transcript of Friday. I think it would more harm the company than it would any other party.
You're saying if you didn't get this transcript for 2 weeks, that it might require an
That would
extension?
essentially be 1 month for the brief.
Let me ask the court reporters, what would be the most practical time that you could do this without being under pressure? Week? No, Friday, if you had to. How about we give you 10 days?
Your Honor, I'm not trying to interfere with any contractual relations with the commission and the court reporter. I was just,
I'm assuming that I have that authority.
okay.
Let's, if we extend it 10 days, would you still need an extension on that? Would you want to move everything back 10 days?
I think that's fair.
What's fair?
Moving 10 days?
So let's go back again. So you want to go from
Had to get
August 20
argumentative with the bitch.
What? Who what?
I believe Mr. Watkins was accidentally not on mute.
Oh, I'm sorry.
Still on the record?
Let's go through this again. I'm sorry to bother everybody with trivial. If you're going to take 10 days, we originally said that the opening brief would be due on 24th. How about we move it back a week to the 31st?
That's fine.
Okay. And then with respect, so I'm going to write down 31.
Monday.
And with respect to the answering brief, rather than October 12th, I'll move it back a week to October the 19th. And with respect to the reply brief, instead of November the 16th, I'll move it back to November 23rd.
That is fine. Thank you.
All right? Okay. All right, the only other thing that I think we talked about briefly, to make sure we're okay, is with respect to the exhibits. Ms. Emerson is going to prepare an exhibit schedule, circulate it to the parties, and then each of the parties would be responsible for uploading the documents to Delafile, being particularly careful with respect to a couple of the confidential documents that need to be marked confidential on and set in on Delafile. And to the extent that there's an issue with that, please coordinate that with the staff of the Public Service Commission.
Your Honor, I believe Ms. Workman is doing that as they've been tracking the exhibits.
Yes, you'll get the exhibits from me, or the exhibit log
Oh, I'm
from
sorry.
me.
You're going to do them all.
No, I'm going to get you the exhibit log.
You're going to do the exhibit log.
Yes, the exhibit list, and I'm going to send it to everybody, and then we'll each upload our own exhibits.
Fair. So ordered. Is there anything further to come before the hearing examiner in this matter?
No, Your Honor.
Hearing nothing?
Your Honor.
Excuse me, there was one last issue that I was asked about. Was there, with respect to closing the docket here, or closing the hearing, was there a document, Mr. Spate, that you were supposed to provide before we closed the record?
Yeah, you gave us, I forget the exact amount of time. Yeah, 1 week to turn in that table for the filter media.
Right. Well, then the record will be closed by me by email at such time as that comes in within a week.
Yeah, that's the only thing that's outstanding, I believe.
There'll be nothing
And
else.
we'll circulate that to all of the parties.
There'll be nothing else submitted to the record except that one document, and the record will be closed at that time. Okay? Hearing adjourned.